Where is the other side? Have you intimated? ಇಲ್ಲ ಬೇಡ ಬಂದಾಗ submission ಮಾಡಿ ಆಗಿದ್ರೆ ಬಂದಾಗ submission ಮಾಡಿ the absence it is not proper. Yes. ಏನ್ರಿ ಒಂದು ರೇಟಲ್ಲಿ ಮೊನ್ನೆ ಬೆಂಚ್ ಮಾಡಿ ಏನ್ ಉಪಯೋಗ? Tuesday
23rd August 33 ಹೇಳಿ ಶ್ರೀಪಾದ್
ಮೇಲಡ ಸಮ್ ಇನ್ಕನ್ವೀನಿಯಂಟ್ 25 ಹಾಕೊಂಡ್ರೆ ಬಹಳ ಉಪಯೋಗ ಆಗ್ತಿತ್ತು.
ಅಲ್ಲ ವಕೀಲ್ರೆ ನೀವ್ ಕೇಳಿದ್ದು ಎಲ್ಲಾ ಅಕಾಮಿಡೇಟ್ ಮಾಡೀನಿ. Because the other side is counsel is not there.
I am ready. ಆದ್ರೆ 33 ಆಯ್ತು ಸರ್, ಆಯ್ತು ಮಾಡ್ತೇನೆ.
My lords, serial number 39, my lords, I appear for the appellant. Kindly pray for a week's time, my lords.
Why, madam?
I'm not keeping well, my lords.
Anyhow, you are attending from through virtual mode.
My lords, just today morning during the walking hours, I felt giddy and fell down. My neighbor got me home. I have to go to the hospital for checkup to know what is wrong.
Then why you are attending? You could have requested any of your colleague, alva?
Oh, my lords, I don't know in the last minute if I tell someone, because at 10 o'clock, if I tell someone, I don't know whether they'll be able to attend. So I thought I have the option of attending online and seeking adjournment.
Okay.
26th August.
Much obliged, my lords.
For order.
Respondent number 4, madam. Appellate may be directed to furnish a copy of appeal memo.
Not claimed ಅಂತ ವಾಪಸ್ ಬಂದಿದೆ ಸರ್. PF ಕಟ್ಟಬೇಕು.
R5 R4
R1
Appear for R4, madam.
R4 ಶ್ರೀಧರ ಅಪಿಯರ್ ಆಗ್ತಾ ಇದ್ದಾರೆ.
R1 no such address
ಅಂತ ಬಂದಿದೆ. R5 ಗೆ ನಾಟ್ ಕ್ಲೈಮ್ಡ್ ಅಂತ ಬಂದಿದೆ.
Intimation delivery not claimed the intimation delivery ಮಾಡಬೇಕು.
ನಾಟ್ ಕ್ಲೈಮ್ಡ್ ಅಂತ ವಾಪಸ್ ಬಂದಿದೆ.
The notice to R5 returned as not claimed. There is an endorsement, postal endorsement that intimation is also delivered. And service of notice to R5 is held sufficient. Notice to R1 is returned unserved with a report that no such address is in existence. Yes, ಏನಾಯ್ತು ನಿಮ್ದು?
R4, I appear for R4. Other side, appellate may kindly be directed to survey a copy of appeal memo, my lord.
ನೀವು ಕಾಪಿನ ಕೊಟ್ಟಿಲ್ಲಲ್ರಿ, ಮತ್ತೆ ಯಾಕೆ ನಾವು ಇಲ್ಲಿ ಡೈರೆಕ್ಷನ್ಸ್ ಕೊಡ್ಬೇಕು? ನೀವು PF ಕೊಟ್ಟ ಅವ್ರಿಗೆ ಸರ್ವ್ ಮಾಡೋದೇ ಬೆಟರ್. The learned counsel for appellant is directed to serve the copy, sufficient copies of appeal memo and other relevant documents to counsel for respondent number 4. You have also not filed power, sir.
Please, my lord, I have to report to the company along with appeal memo. Then only they will send the wakalat.
ಕೊಡಿ ವಕೀಲರವ್ರಿಗೆ. Please the matter after 2 weeks for steps to R1. R1 steps to.
Lord, I am appearing for the Lord appellant insurance company. So far respondent number 4 is concerned, Lord, as per the postal charade, Lord, I have refused. Therefore, my request is that, Lord, so far respondent number 4 may be held, service as held sufficient. Lord.
Notice to R4 issued to register post is returned with postal endorsement as refused. R4 is absent. Service is held sufficient. Complete ಆಯ್ತಲ್ಲ? Please the matter for admission after 2 weeks.
Much obliged.
My lord, I am appearing for the appellant, my lord. 2 weeks time I grant you to take steps to R1 and R2, my lord.
As per the request of the learned counsel for appellant, leaves the matter up to 2 weeks finally.
Please, my lord. Applies. Monday, adu nonde matter, my lord. Same order may kindly be passed, my lord.
Same repeat.
My lord, otherly none an appellant, same order may kindly be passed, my lord, for taking steps.
Adu same.
Star promote retirement memo ಹಾಕಿದ್ದಾರೆ ಸರ್ ಅರ್ಚನಾ ಮೂರ್ತಿ NSC Appellate.
I am appearing for the appellant, my lord.
ಪಕ್ಕದಲ್ಲಿ ಹಾಕಿದ್ದಾರೆ ಇದು retirement.
I have filed an OC wakalat, my lords.
Srimati Archana Murthy filed power for appellant with NOC from R. Pramod. The power is placed on record. Registry is directed to delete the name of Pramod R from the cause list. Please the matter.
There is a connected appeal, my lord, 7016 of 17.
70
16 of 17.
17. Please the matter
Please, ma'am.
along with MFA 7016 of 2017 after 2 weeks.
Sorry,
My
my lord.
lords, kindly date may be fixed, my lord.
Madam, 17, 18, 19 ಅಷ್ಟೇ ಬರ್ತದೆ. 2 weeks means 2 weeks. The same day after 2 weeks it will come.
Much of it.
Sorry, my lord, for interference. Serial number 6 ಕೂಡ ನಾನು appellant ಅದು
ಆಯ್ತು
correct
ಅದು
ಆಗಿ
ಕೊಟ್ಟಿದ್ದೀರಿ
ಸರಿ, sorry, my lord. I will not.
Number 8 ಶ್ರೀ ಆರ್ ಡಿ ರೇಣುಕಾರಾಧ್ಯ ಡಿಸ್ಪೆನ್ಸೇಷನ್ ಮೆಮೋ ಹಾಕಿದ್ದಾರೆ ಸರ್ ಇವರು ತೆಗ್ದಿತ್ತು ಅದನ್ನು
Learned counsel for appellant filed memo for dispensation of notice to R1. Memo is placed on record. Notice to R1 is dispensed with at the risk of the appellant. List the matter for admission after 2 weeks. The learned counsel for appellant submit that needful has been done. Office to verify and proceed. I cannot know because the jurisdiction of this court is barred. Then see, when this court doesn't have any jurisdiction, you want that I should consider the amendment application and then decide the jurisdiction. How can it be done? Huh? What is the now claim amount? Correct. The valuation heard the learned counsel for appellant. The valuation made in the appeal memo para number 16 disclose that the valuation is 22 lakhs, which is more beyond the jurisdiction of this court. As such, list the matter. Registry is required. Registry is directed to list the matter before division bench after obtaining necessary. Notice to R1 to R3 unserved. Learned counsel for appellant is directed to take further steps. Please stop to 2 weeks.
ಆರ್ಡರ್ ಆಗಿತ್ತು ಇದನ್ನ ರಿಕಾಲ್ ಮಾಡಿ ಕೇಳ್ಕೊಂಡಿದ್ದಾರೆ ಅಯ್ಯೇ ಹಾಕೊಂಡಿದ್ದಾರೆ ಪ್ರಿಂಟರ್
The Learned Counsel for Appellant. Called out absent. You are for appellant. ಈ ಕಡೆ ನಿಂತ್ರೆ ನಾವು ಕನ್ಫ್ಯೂಷನ್ ಆಗೋಲ್ಲನ್ರಿ ಹಾ Have you complied the office objections? Have you complied office objections? First ಕೇಳ್ತಾ ಇದ್ದೀನಿ ಇಲ್ಲ keeping open I 1 of 18 and 1 of 22 the Learned Counsel for Appellant is permitted to comply the office objection. Please the matter after compliance of the office objection after 2 weeks. Comply ಮಾಡಿ ಮೊದಲು ನೋಡೋಣ then we will decide. Lord the Learned. Yes, what you have to say?
Kindly refer the matter to Lok Adalat. So,
Hey madam, yeah, stage ಇದೆ ಮತ್ತೆ ಅದನ್ನ ಬಿಟ್ಟು ಡೈರೆಕ್ಟ್ಲಿ along with I1 you want that matter should be referred to Lok Adalat. Lok Adalat has got any powers to condone the delay. ಮತ್ತೆ heard the Learned Counsel for Appellant. There is I1 of 2017 is filed for condonation of delay of 191 days. The Learned Counsel for respondent number 2 is absent. Considering the grounds urged, I1 of 2017 is allowed and delay of 191 days is condoned, subject to denial of interest for the said period. As per request, refer the matter to Lok Adalat.
Ravishankar Chapri.
Third bill on I number 1 of 18, there is delay of 17 days in filing the appeal. Considering the grounds urged, delay of 17 days is condoned by allowing I 1 of 18. Yes. ಯಾಕ್ರಿ ಬಾಳ ದಿನ ಆಯ್ತು ಅವ್ರು ನೋಡೇ ಇಲ್ಲಲ್ರಿ ಅಂಡ್ ವರ್ಚುವಲಿ ನೀವೇ ಆಲ್ಮೋಸ್ಟ್ ಕಾಂಟ್ಯಾಕ್ಟ್ ಪ್ರಾಸಿಕ್ಯೂಟ್ ಮಾಡ್ತಾ ಇದ್ರಿ ಅವ್ರ ಪರವಾಗೆಲ್ಲ ಮಂಡೇ ಇಡ್ಲಾ Please the matter on Monday for admission.
Number 18, N. Gopala Krishna.
Third, both the councils on I 1 of 19. There is delay of 84 days in filing the appeal. Considering the grounds urged, IA1 of 19 is allowed and delay of 84 days in filing the appeal stands condoned. Death case or T-shares ಬೇಕಾ ನಿಮ್ಗೆ?
Liability exonerated of that.
You are a owner or you are the claimant? Owner is not, and you have sought dispensation of notice to owner when you are asserting that liability, liability is fastened on owner. You want to give up the claim against owner. How it happens? Whether DL is secondary. Liability iddaga ನೀವು see, dispensation is different. Moving an application under proper provision because he was ex parte, there is no need to issue notice ಅನ್ನೋದು ಬೇರೆ. ನೀವು dispensation ಕೇಳಿದಿರಿ, and it is at your risk only. I'm not coming in your way. Call for TCR. ಎಲ್ಲಿಂದ ಬರ್ತದೆ? Death case first appeal already. Statutory right ಇರುತ್ತೆ ಅದರಲ್ಲಿ. Call for TCRs. ಎಲ್ಲಿಂದ ಬರ್ಬೇಕ್ರಿ TCRs? ಬೆಂಗಳೂರು. Please the matter on 29/8.
29th August. CL number 19, Sri M.Y. Srinivasan.
Second respondent.
Apply for the appellant, my lord. The 33 days delay, my lord.
Delay.
ಅಲ್ಲ ಈ ಕನೆಕ್ಟ್ ಮಾಡೋಣ. I 30 days delay. Third, both the councils, there is delay of I1 of 19 is filed for condonation of delay of 33 days in filing the appeal. Considering the grounds urged, I1 of 2019 is allowed and delay of 33 days in filing the appeal stands condoned. Please the matter along with MFA
2642 of 19.
only quantum Tuesday.
23rd August. CL number 20, Sri M. Gopalakrishna.
I am appearing for the respondent, my lordship.
Yes,
Delay condone ಮಾಡಬಹುದು ಸ್ವಾಮಿ without interest, my lord.
ಸರ್ ವಕೀಲ್ರ 6 ತಿಂಗಳು ಇಲ್ಲ 4 ತಿಂಗಳು ಇಂಟ್ರೆಸ್ಟ್ 114 ದಿನ.
ಅಲ್ಲ
You can
ಸ್ವಲ್ಪ dispute
understand
ಆಗಿದೆ ಒಂದ್ ವೇಳೆ
at least ಅದು ಅದರಿಂದ ಏನು ಸ್ವಲ್ಪ ಆಗ್ತಿದೆ ಏನ್ರಿ?
ಹಂಗಲ್ಲ ಬೇಡ ನಾ ಕೇಳೋದು ಕೇಳ್ತೀರಿ ಅದು ಕೋರ್ಟ್ ಬಿಟ್ಟಿದ್ದು ಸ್ವಾಮಿ.
Heard both the councils on I number 1 of 19, there is delay of 114 days in filing the appeal. Considering the grounds urged, I1 of 19 is allowed by condoning the delay of 114 days in filing the appeal. In case of death or injury, liability and dispute ಇದೆ.
Here also.
Negligence. Call for T-shares. Please the matter on 19.
CL number 21, Srimati A.R. Sharadamba. Rania is here. Respondents.
I appear for respondent, my lord.
Delay. Yes,
The delay of 2 days, my lord.
You are for respondent alva?
Respondent, my lord.
Condone ಮಾಡಬಹುದಾ?
ಮಾಡಬಹುದು ಸ್ವಾಮಿ.
Heard on I number 1 of 19, there is delay of 226 days in filing the appeal. Considering the grounds urged in I number 1 of 19, delay of 226 days is condoned subject to denial of interest for the said period. In death case, What liability is undisputed. Yes, madam, ಏನ್ ಹೇಳ್ತೀರಾ? What is the age of the deceased?
Maybe taken up on the next date of hearing, my lord.
ಏನ್ ಮೇಡಮ್ ಇದು ಎಲ್ಲ ಕ್ಯಾಲ್ಕುಲೇಟ್ ಲಯಬಿಲಿಟಿ ಡಿಸ್ಪ್ಯೂಟ್ ಇಲ್ಲ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ. ಎಲ್ಲ ಮ್ಯಾಥಮೆಟಿಕಲ್ ಕ್ಯಾಲ್ಕುಲೇಷನ್ ದೆನ್.
Recently, we have filed local. Next date of hearing will be present in the court, my lord.
Monday,
This month.
Tuesday. ಒಳ್ಳೆ ದಿನ ಇದೇನ್ರಿ? Wednesday. Is the matter on Wednesday, on 24th August for admission.
Admission matters, serial number 20 to 23 adjourned, 24 Sri Ashok and Patil. Yes, Srinivas Ayyappa, electronic number 5. Ashok and Patil.
Liability ಏನ್ರಿ ಡಿಸ್ಪ್ಯೂಟ್ ಆಗಿದೆನಾ? ಅಲ್ಲ ಗ್ರೌಂಡ್ ತಗೊಳ್ಳಿ. Liability is fastened on insurance company. You are aggrieved by the quantum. ಹೌದಾ? What is the nature of injury? Loss of income during laid up period ಕೊಟ್ಟಿಲ್ಲ. What he was doing? So it should have been 8,500. ಇದ್ರಿಗೆ ಇನ್ಕಮ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಬಹುದು. ನೋಡೋಣ ಅವ್ರು ಬಂದ್ರೆ ನೋಡೋಣ. ದಿ ಅದರ್ ಸೈಡ್ ಇಟ್ಟಿದ್ದೀನಿ, ನೋಡೋಣ ಪಾಸ್ವರ್ಡ್.
ಸೆಟ್ಲ್ ಆಗಿದೆ ಅಂತ ಪೇಮೆಂಟ್ ಸಬ್ಸಿಡಿ ಅದೆರಡು ಎಂಸಿ ನಂಬರ್ ನಾನು ಹಾಕಿರೋದು ಅಪೀಲ್ ವ್ಯಾಲ್ಯೂ ಆಯ್ತು ಆರ್ಗ್ಯುಮೆಂಟ್ ಲೋಕಲ್ ಸೆಟಲ್ಮೆಂಟ್ ಮಾಡ್ದಂಗೆ ಡಿಫರೆಂಟ್ ಅಡ್ವೊಕೇಟ್
ಅಲ್ಲ ಸೆಟ್ಲ್ ಆಗಿದ್ರೆ ಇಲ್ಲಾದ್ರೂ ನೀವು ಲಯಬಿಲಿಟಿ ಇಸ್ ನಾಟ್ ಡಿಸ್ಪ್ಯೂಟೆಡ್ ಅಲ್ಲ.
ಏನಂದ್ರೆ ನನ್ನ ಅಪೀಲ್ ಸೋಮವಾಗಲ್ಲ ಅವಾಗ.
ನಿಮ್ದು ಯಾವ್ದು ಅಪೀಲ್ ಇದೆ? 5088 is filed by you and 5089. So 3 appeals filed by you. Now you are disputing the quantum or liability. If it is settled, you are out of the court. Tuesday, na? As per the request of the learned counsel, P. Pradeep, please the matter on Tuesday.
3rd August, the number 27 adjourned, 28, the judge.
List ಆಗಿದೆ sir.
In case of death. I'm appealing for one case. In another case, I have to amend.
ಕೊಡಿ ಯಾವ್ದಾದ್ರು ಒಂದು ನೋಡಿ. You are appellant in 4648 7648 you are appellant. So you are the claimant. You are the owner of the vehicle. Oh. That will be considered along with the appeal memo only, not, it cannot be heard independently. ಒಂದ್ ನಿಮಿಷ ಅವ್ರು ಹೇಳ್ತಾರೆ ಕೇಳಿ, ನಿಮ್ಮನ್ನು ಖ್ಯಾತಿನಿ ಇಟ್ಟಿದ್ದೀನಿ. ಒಂದ್ ನಿಮಿಷ. You have produced two Xerox copies. They are not the original documents. One is though. Then why you reject the? See, you are seeking production of document that too in appellate state by moving an application under Order 41 Rule 27, and you want to produce a Xerox copy by retaining original. You do one thing, you retain the original. I'll consider the Xerox copy and reject the application. No, sorry, sir. See, no. Why you want to retain the original if you want to rely that document? See, I will produce, has no relevance at all. You should have produced it along with this application. See, their application is going to be rejected only on the ground that it is a Xerox copy. The payment of 6 lakhs which you assert is only towards treatment, not towards compensation. No, sir. Towards treatment and wordings ಇದೆ. ಯಾರು? See, ನಿಮಗೆ 2 agreement ಅದಾವ. 3 lakhs payment ಇದ್ದು. Total 3 lakhs, 2 agreements. Total 6 lakhs, but not a single agreement under 2 agreements. 3 lakhs. That is for treatment. Initial 3 lakhs for first treatment. Insufficient and further 3 lakhs 43. It is towards treatment, not settlement. Nimde document ಹೇಳ್ತಾ ಇದ್ದೀನಿ ಸ್ವಾಮಿ ನಾನು. I am not raising his defense or anything. What your documents is. Then see, either consider ಮಾಡಿದ್ರೆ how you are entitled to get when. Sir, court ಗೆ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ರು ಮಿಸ್ ಆಗುತ್ತಾ ನಿಮ್ಗೆ? So you don't have trust in the courts ಅಂದಂಗಾಯ್ತು. What you are submitting, sir? And ನಿಮ್ ಕಡೆ ನಿಮ್ ಪಕ್ಷರಿಗೆ ಹೇಳಿಬಿಟ್ಟು ಅವನ ಹತ್ರ ಇಟ್ಕೊಂಡ್ಬಿಡ್ಲಿ ಪರ್ಮನೆಂಟ್ಲಿ. This is ಏನ್ರಿ? And how this is permissible? ಇನ್ನೊಂದು legal question ಕೇಳ್ತೀನಿ. The petitioners 2 to 4, 2 and 3 are minors. How can you enter into an agreement with minors? Is it binding on minors? Is it binding on minors? ಎಲ್ಲ ಪ್ರಶ್ನೆಗಳು ಬರ್ತಾವ ಸ್ವಾಮಿ. ಅಂಡ್ ಇಷ್ಟೆಲ್ಲ ಇದ್ದು ಒರಿಜಿನಲ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಲು ಒರಿಜಿನಲ್ ನಿಮ್ಮ ಸ್ಟೇಪ್ ಕಸ್ಟಡಿ ಒಳಗೆ ಇಟ್ಕೊಂಡು ಜೆರಾಕ್ಸ್ ಕಾಪಿ ಮೇಲೆ ನಿಮ್ ಕಡೆ ಕಳಿತದ ಅಂತ ಹೇಳಿ ಜೆರಾಕ್ಸ್ ಕಾಪಿ ಒಳಗೆ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ತಾ ಇದ್ರಿ. ನಿಮ್ಮ ಹತ್ರ ಇಟ್ಕೊಂಡ್ ಬಿಡಿ ಅದು. ಕೋರ್ಟ್ ಒಳಗೆ ಕಳಿತದಲ್ಲ ನಿಮ್ಗೆ. Sir, please, this is very offending statement. ತರಿಸ್ಕೊಡ್ತೀನಿ ಅಂದ್ರೆ are you making any favor to the court? ಅಲ್ಲ, are you making any favor to the court by submitting that you will get that document? ತರಿಸ್ಕೊಡ್ತೀನಿ ಅಂತಂದ್ರೆ ಏನು? 2 weeks forget sir. 2 weeks ಏನು ಇಲ್ಲ. ಆಕ್ಸಿಡೆಂಟ್ ಆಗಿ ಎಷ್ಟು ದಿನದ ಮೇಲೆ ತೀರ್ಕೊಂಡಿದ್ದಾನ್ರಿ? Date of accident is 23/4/2016. When he died? ನೀವೇ ಹೇಳ್ಬೇಕಲ್ಲ ಸ್ವಾಮಿ. $9,500 ತಗೋಬೇಕಾಗಿತ್ತು, 8,000 ತಗೊಂಡಿದ್ದಾರೆ. ಇನ್ನ ಎನಾನ್ಸ್ ಆಗತ್ತೆ ಸ್ವಾಮಿ. ಕನ್ಸೋರ್ಟಿಯಂ ಇನ್ನ 120 ಬರ್ಬೇಕು. ನಿಮ್ಮ ಟೈಮ್ ಕೊಡ್ತೀನಿ ಅಂತ ಸಬ್ಜೆಕ್ಟ್ ಟು ಡಿಪಾಸಿಟ್ ಆಫ್ ಸರ್ಟನ್ ಅಮೌಂಟ್. ಏನು ಡಿಪಾಸಿಟ್ ಮಾಡಕ್ ರೆಡಿ ಇಲ್ಲ. ನಾನು ಕೆಳಗಿಂದ ಆರ್ಡರ್ ಸ್ಟೇ ಮಾಡಕ್ ಆಗಲ್ಲ ಹಾಗಿದ್ರೆ. ಅದಕ್ಕೆ ನಾನು ವಿಲ್ ನಾಟ್ ಸ್ಟೇ ಆಗಿಲ್ಲ ಅಲ್ಲ ಟ್ಯೂಸ್ಡೇ. ನೋ ನೋ ಸರ್. ಅವ್ ಕಡೂರದಿಂದ ಇಲ್ಲಿಂದ 4 ತಾಸು ಬರ್ತಾರೆ. ಡೈಲಿ ಒಂದು 15 ಟ್ರೈನ್ಸ್ ಅವ. ಏನ್ ಸರ್ ಹೇಳ್ತೀರಾ ನೀವು? ನೋ ಸರ್, ನೋ ಸರ್. ನೀವು ಮಾಡಿ ನಿಮ್ ತಪ್ಪಿಗೆ ನೀವು ಫಾರ್ ಯುವರ್ ಫಾಲ್ಟ್ ವೈ ಯು ಆರ್ ಬ್ಲೇಮಿಂಗ್ ದಿ petty appellants. 25/8 finally.
Number 29,
ಇನ್ನೊಬ್ಬ ಕಲತ ಹಾಕಿಲ್ಲಲ್ಲ ಅವರು. ಅಲ್ಲಿ ಇರ್ಲಿ ಅಲ್ಲ, ಹೀಸ್ ಫಾರ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಅಲ್ಲ. ಶ್ರೀ ಜಗದೀಶ್ ಡಿಸಿ, ಶ್ರೀ DC Jagdish for respondent in MFA 2578/2019 takes notice. The copies are served on him. Leaves the matter on 25. ಅವತ್ತಿನ ಹಾಕ್ಲಿ ಅವರು.
number 29.
The liability is not disputed. So tribunal has held that there is actionable negligence on the part of the claimant. Yes, there negligence.
Was a villain writer on the the board has learned that this is a part of matter. And also, that also has not been considered by the person.
What is the nature of injury?
Numerous phone and similar to the payments. Customer immediately one of
What of a kidney? Whether a doctor is examined, the injury to the kidney was caused because of this accident which has compelled the kidney to be removed and then the evidence is there. Because what the evidence shows that the non-function of left kidney and it may be earlier, non-functioning may be earlier itself. But the kidney failure because of this accident can rebekala. If the kidney was removed because of the accidental injuries, okay, it amounts to a very serious lapses. But if the kidney was not functioning since beginning, then things are different. Whether this doctor is examined along 3. Node illal doctor Neve or evident nodilla has specifically stated that the kidney loss was because of trauma to the renal vessels and ಹೇಳ್ತಾ ಇದ್ದಾರೆ. ನೀವು ಅದನ್ನ ಹೇಳ್ತಾನೆ ಇಲ್ಲ. Who is appearing for corporation? This is appeal by corporation. Hello, kidney loss doctor has stated you have cross-examined him and he has given explanation damage to the internal organ. Therefore, 1/3 rule cannot be applied. It should be only in respect of half 50%. Loss of one kidney, because now because of loss of one kidney he cannot lift heavy objects. He cannot do strenuous work and he is hardly aged about 17 years. And he was required to undergo one more operation because intestine there is some gap that is to be filled up. Claimant has not filed any appeal. What is case made out by you then? Correct. Yes. Now law is settled. He is a third party. He is a third party. He can prosecute either of them. Charge sheet is submitted against. Then what evidence you are led to disprove the yes. ಏನ್ ಹೇಳುತ್ತೆ ಅದು? Whether the corporation has challenged the charge sheet, then your driver has been prosecuted, but you have not challenged the charge sheet. Then still worse case. Still worse case. ಅಲ್ಲ ಸ್ಟಿಲ್ ವರ್ಸ್ ಕೇಸ್ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದೀನಿ. ಅದಕ್ಕೆ ಅಟ್ ಲೀಸ್ಟ್ ಎಜುಕೇಟ್ ಆಗಿದ್ದಂದ್ರೆ ಆಫೀಸ್ ಕೆಲಸರೇ ಮಾಡ್ಬೋದಾಗಿತ್ತು. ನೌ ಹಿ ಹ್ಯಾಸ್ ಟು ಡೂ ಕೂಲಿ. The allegations in the charge sheet is that you came from left side. He was moving on the normal side. You tried to overtake him from left side. If there is a delay in lodging the complaint, the accident is admitted, nature of injury is admitted, only delay. It is the duty of the police to, then what prevented you to report the accident immediately to the nearest police station? You are a public servant. The allegation is that you did not even bother to stop at the spot, fled from the spot immediately after the accident along with the bus. Then ಆಯ್ತು ನಿಮ್ ಪ್ರಕಾರ ನಿಮ್ ತಪ್ಪಿರ್ಲಿಲ್ಲ ಅಂತಂದ್ರೆ what is expected from you? Should have stopped the bus, you should have moved the injured to the hospital and then reported that he himself there is a negligence. It would have been your first report. You won't stop your vehicle, you flee away, you don't even attend the injured, and now you are raising the ground of delay. ಅಲ್ಲ ಅವ್ರು ಟ್ವಿಸ್ಟ್ ಮಾಡಿದಾರೆ, ನೀವ್ ಯಾಕೆ ಟ್ವಿಸ್ಟ್? ನಿಮಗೆ ಅಪರ್ಚುನಿಟಿ ಇರ್ತಾವಿಲ್ರಿ. ಅದಕ್ಕೆ ಹೇಳೋದು ನಾನು, when your vehicle was involved in the accident, when it is not disputed, it is expected from the driver to report the accident immediately to the nearest police station. He was duty bound to report the accident. He was duty bound to shift the injured to the hospital. Even otherwise, whether he has reported to the depot manager, that was also not there. Depot manager report ಮಾಡಬಹುದಾಗಿತ್ತು, ಏನೂ ಮಾಡಲ್ಲ. ಏನಿದೆ? Had you prompt, had you lodged a complaint immediately disclosing that this is the actual of aspect, it was his fault, he fell in a hump which has resulted in hitting the bus which was following him. So rider of the two-wheeler may be prosecuted on complaint ಕೊಟ್ಟಿದ್ರೆ ಅಂದ್ರೆ things would have been different already. ಮತ್ತೆ ಅದೇನು ಮಾಡಲ್ಲ ನೀವು. ಅಪೀಲ್ ಸ್ಟೇಜ್ ಒಳಗೆ ಬಂದು ಇಲ್ಲ ಡಿಲೇ ಅದ, ಅವರು ಟ್ವಿಸ್ಟ್ ಮಾಡಿದಾರ ಅಂತ ಹೇಳಿ ಈಗ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿದ್ರೆ ನಿಮ್ಗೆ ಅಪೋರ್ಚುನಿಟಿ ಏನೂ ಮಾಡ್ಲಿಲ್ಲಲ್ಲ. ಅವ್ರು ಟ್ವಿಸ್ಟ್ ಮಾಡ್ಯಾರ ಅಂತ ಹೇಳಿ ಒಪ್ಕೊಳ್ಳಂತ, ಲೆಟ್ ಅಸ್ ಅಕ್ಸೆಪ್ಟ್ ಇಟ್. ವೆನ್ ಯು ಅಡ್ಮಿಟೆಡ್ ದಿ ಆಕ್ಸಿಡೆಂಟ್, ವಾಟ್ ಈಸ್ ದಿ ಡ್ಯೂಟಿ ಕಾಸ್ಟೆಡ್ ಆನ್ ಯು ಅಂತ ನಾನು ಕೇಳ್ತಾ ಇದ್ದೀನಿ. ನೀವು ರಿಪೋರ್ಟ್ ಮಾಡ್ಬೇಕಾಗಿತ್ತು. When you have not reported the accident, having admitted the accident, adverse inference is required to be drawn against you, alva? Simple, alva? Accident. Police station ಹೇಳ್ಬೇಕಾಗಿತ್ತು. He should have set the law in motion. He doesn't take any steps. Now the corporation says that we admit the accident, but the facts are twisted. Have you examined your driver? No. What is his explanation for not lodging the complaint? You admit driver is examined, he admits accident, shifted him in the auto. Antunu ಹೇಳ್ತಾನೆ. Why you are not lodged the complaint? ಯಾರಿಗೆ ರಿಪೋರ್ಟ್ ಮಾಡಿದ್ದಾರೆ? Where is the where is the documentary? ಆಯ್ತು, ಪೊಲೀಸರಿಗೆ ಹೇಳಿದ್ರಿ, ಪೊಲೀಸರು ಏನು ತಗೊಂಡಿಲ್ಲ ಅಂತ ಇದೆ. ನಿಮ್ಮ ಡಿಪೋ ಮ್ಯಾನೇಜರ್ ಅಂತೂ ಇಂಟಿಮೇಟ್ ಮಾಡ್ಲೇಬೇಕು. ಎಲ್ಲ ಹೇಳ್ತೀವಿ ಅಂದ್ರೆ he is required. See, yours is a corporation, sir. ಅಲ್ಲ, ನೀವು ಹೇಳೋದು ಓರಲ್ ನಡೆಯಲ್ಲ, ನಿಮ್ಮಲ್ಲಿ ರೈಟಿಂಗ್ ಒಳಗೆ ಒಂದು ಮೆಮೊ ಕೊಡ್ತಾರ, ಅಲ್ಲಿ ಒಂದು ಸಬ್ಮಿಷನ್ ನೋಟ್ ಇರುತ್ತೆ. ದಿಸ್ ವೆಹಿಕಲ್ ಇಸ್ ಮೆಟ್ ವಿತ್ ಅನ್ ಆಕ್ಸಿಡೆಂಟ್, ಐ ಹ್ಯಾವ್ ಶಿಫ್ಟೆಡ್, ಇಟ್ ಈಸ್ ದಿ ಫಾಲ್ಟ್ ಆಫ್ ದಿ ರೈಡರ್, ಐ ಹ್ಯಾವ್ ಅಟೆಂಡೆಡ್ ಹಿಮ್ ಅಂತ ಹೇಳಿ ಒಂದು ಮೆಮೊ, ಒಂದು ಎಕ್ಸ್ಪ್ಲನೇಷನ್ ಕೊಟ್ಟು ರಿಪೋರ್ಟ್ ಮಾಡಿದ್ದೀರಾ? Because you are directly under the control of depot manager or traffic inspector. ಅವ್ರಿಬ್ಬರಿಗೂ ರಿಪೋರ್ಟ್ ಮಾಡ್ಬೇಕು. ನೀವು ಇಬ್ಬರಿಗೂ ಮಾಡ್ಲಿಲ್ಲ, ನೀವು ಮಾಡಿ ಒಂದ್ 100 ಹೇಳ್ತೀರ ಬಿಡಿ. ಓರಲ್ yours is a corporation, oral is not permissible. ಅವ್ರಿಗೆ ಗೊತ್ತೇ ಇಲ್ಲ ನಿಮ್ ಆಕ್ಸಿಡೆಂಟ್ ಆಗಿದ್ದಂಗಿದ್ರೆ. Only when your vehicle is seized 2 days after, they got knowledge of the accident. ಈಗ ನೀವು ತನ್ನ ಸ್ಕಿನ್ ಸೇವ್ ಮಾಡಕ್ ಅವನ ಮ್ಯಾಗ ಡಿನು ಮಾಡಿರ್ಬೇಕು ಅವರು. ನೀವು 100% ಮಾಡಿರ್ತೀರ. ಕಾಂಪೆನ್ಸೇಷನ್ ಅವಾರ್ಡೆಡ್ ರೀಸನೇಬಲ್ ಏನ್ರಿ? ಇನ್ನೊಂದು ಕೇಳ್ತೀನಿ ನಾನು ನಿಮಗೆ. 6,84,000 ಕೊಟ್ಟಿದ್ದಾರೆ. there is a loss of 1 left kidney ನ ಹೋಗಿದೆ ಅವನು. ಸರ, ಸ್ಟೂಡೆಂಟ್ ಇರ್ಲಿ ಎಲ್ಲ ಇರ್ಲಿ, he lost a kidney, 1 kidney ಹೇಳ್ತಾರಲ್ಲ, that is medical evidence, it is proved. Loss of kidney ಎಷ್ಟಾಗ್ಬೇಕ್ರಿ? Very sad state is the claimant has not filed an appeal, and you are coming in appeal. Very interesting. ಬರಲ್ ಹೇಗ್ ಸ್ವಾಮಿ? 1 ಕಿಡ್ನಿ ಲಾಸ್ ಆಗಿದೆ, 17 ವರ್ಷದ ಹುಡುಗ, ಅವನ್ ಲೈಫ್ ಹೋಯ್ತು, ಮ್ಯಾರೇಜ್ ಪ್ರಾಸ್ಪೆಕ್ಟ್ಸ್ ಹೋಯ್ತು, ಲೇಬೋರಿಯಸ್ ವರ್ಕ್ ಮಾಡಕ್ ಬರಲ್ಲ. ಡೇ ಟು ಡೇ ಆಕ್ಟಿವಿಟೀಸ್ ಅಂದ್ರೆ ನಡೆದಾಡ್ಬೋದು, ಊಟ ಮಾಡ್ಬೋದು, ಟೇಬಲ್ ವರ್ಕ್ ಮಾಡ್ಬೋದು. ಟೇಬಲ್ ನೌಕರಿ ಕೊಡ್ತೀರಾ? ಕೊಡಿ ನೌಕರಿ. ಗಿವ್ ಹಿಮ್ ಅನ್ ಎಂಪ್ಲಾಯ್ಮೆಂಟ್, ಮ್ಯಾಟ್ರಿ ends there. $40,000 ಕೊಟ್ಟಿದ್ದ, ಏನ್ ಸರ್ ಇದು? 60,000 ಪೇನ್ ಅಂಡ್ ಅಗ್ವನಿ ಕೊಟ್ಟಿದ್ದಾರೆ ಕಿಡ್ನಿ ಲಾಸ್ಗೆ. And he is required to undergo 1 more operation ಅಂತನೂ ಹೇಳ್ತಾರೆ. Very meager has been granted, still you are coming in appeal. ನಾನು ಕಾಂಟ್ರಾ ರಿವ್ಯೂ ತಗೋಬಹುದಾ? ಜಸ್ಟ್ ಕಾಂಪೆನ್ಸೇಷನ್ ಗ್ರೌಂಡ್ ಮ್ಯಾಗ ಹೋಗ್ಬೋದಾ? This is one of the fit case ಅಂತ ಹೇಳಿ ಅಬ್ಸರ್ವೇಷನ್ ಮಾಡ್ತೀನಿ. ಸುಪ್ರೀಂ ಕೋರ್ಟಿಗೆ ಹೋಗ್ರಿ. ಏನ್ ಮಾಡ್ತೀರಾ ಈಗ ನೀವು? ಅಪೀಲು ಅದನ್ನೇ ಕೇಳ್ತಾ ಇದ್ದೀನಿ ಅವ್ರಿಗೆ. See, the rule is just compensation. In all cases, okay. I do consider it not in all cases. It is not a general rule, but it is an exception rule. And this is one of the exceptional cases. Loss of kidney. Loss of kidney $60,000 ಕೊಡ್ತಾರೆ ಸರ್. ನೀವು ಮಾರ್ಕೆಟ್ ದೊಳಗೆ ಹೋದ್ರೆ $60,000 ಕಿಡ್ನಿ ಸಿಗುತ್ತೆ, ಕಿಡ್ನಿ ಸಿಗಲ್ಲ ನಿಮಗೆ. ಕ್ಯೂ ಹಚ್ಬೇಕು. ಅದು ನಿಮಗೆ ಈಗ ಕೊಡಲ್ಲ ಅವರು. ಒಂದ್ ಕಿಡ್ನಿ ಇದ್ದವ್ರಿಗೆ ಕೊಡಲ್ಲ, 2 ಹೋದವ್ರಿಗೆ ಅಷ್ಟೇ ಕೊಡ್ತಾರೆ. ಮತ್ತೆ there is a lot of procedure. ಇಲ್ಲ ಯಾಕಂದ್ರೆ ಲಾಟ್ ಆಫ್ ಇದು ನಡೀತಾ ಇದೆ. ಇಟ್ ಹ್ಯಾಸ್ ಬಿಕಮ್ ಎ ರಾಕೆಟ್ ಆಲ್ಸೋ. ಮಾಫಿಯಾ ಇದೆ ಅದಕ್ಕೆ ಒಂದು. ದೇರ್ ಆರ್ ಡಿಫರೆಂಟ್ ರೀಸನ್ಸ್. ಬ್ಲಡ್ ಗ್ರೂಪ್ ಮ್ಯಾಚ್ ಆಗ್ಬೇಕು, ಎವ್ರಿಥಿಂಗ್. ಏನ್ ಮಾಡ್ತೀರಾ? ನಾನು ಹೇಳ್ತೀನಿ, ನಾನು ಮೆರಿಟ್ಸ್ ಮ್ಯಾಗ ಹೋದ್ನಿ ಅಂದ್ರೆ ಐ ಆಮ್ ಗೋಯಿಂಗ್ ಟು ಎನ್ಹಾನ್ಸ್. On merits, I am going to enhance. Dismiss merits ಮ್ಯಾಗ ಮಾಡಿದ್ನಿ ಅಂದ್ರೆ ಎನ್ಹಾನ್ಸ್ ಮಾಡ್ತೀನಿ ನಾನು ಅಂತ ಹೇಳಿದ್ ನಾನು. ನಾಟ್ ಪ್ರೆಸೆಂಟ್ ಮೆಮೊ ಹಾಕಿದ್ರೆ ಕ್ಲೋಸ್ ಮಾಡ್ತೀನಿ ನಾನು. ನೋಡಿ ಕೇಳಿ, ನಿಮ್ ಕಾರ್ಪೊರೇಷನ್ ದವ್ರಿಗೆ ಏನು ಸ್ಟೆಪ್ಸ್ ತಗೊಂಡಿಲ್ಲ. ಮೆರಿಟ್ಸ್ ಮೇಲೆ ಹೋದಂದ್ರೆ ಯು ಡೋಂಟ್ ಹ್ಯಾವ್ ಎನಿ ಕೇಸ್ ಬಿಕಾಸ್ ಆಫ್ ದಿ attitude of the corporation, attitude of the driver in not reporting the accident, subsequently admitting the accident. Admit ಮಾಡಿಬಿಟ್ಟಿದ್ದೀರಿ. ಮತ್ತೆ accident dispute ಮಾಡಿಲ್ಲ. Now you are making that they have twisted the facts. Correct manner of the accident they have twisted. You are the best witness. ನಿಮಗೆ ಏನ್ ಗಾಯ ಇರ್ಲಿಲ್ಲ. You could have reported the matter. ರೈಟಿಂಗ್ ಒಳಗೆ ಕೊಡ್ಬೇಕು ಸ್ವಾಮಿ. You are a employee, public servant, corporation ಇಂದ ಬಂದವರು. See, now if I go for negligence ಆದ್ಮೇಲೆ ಹೋದ್ಮೇಲೆ ಡಿಸ್ಮಿಸ್ ಮಾಡ್ಬೇಕಂತಂದ್ರು ವರ್ಚುವಲಿ ಐ ಹ್ಯಾವ್ ಟು ವಾಟ್ ಈಸ್ ದಿ ಕಾಂಪೆನ್ಸೇಷನ್ ಅಂತ ಹೇಳಬೇಕಾಗತ್ತೆ. ನೆಗ್ಲಿಜೆನ್ಸ್ ಅಂದ್ರೆ ನೀವು ಡೋಂಟ್ ಹ್ಯಾವ್ ಎನಿ ಕೇಸ್ ಅಟ್ ಆಲ್. ಯಾಕಂದ್ರೆ ನಿಮ್ದು ಓರಲ್ ಡ್ರೈವರ್ ಓರಲ್ ಎವಿಡೆನ್ಸ್ ಬಿಟ್ಟು ಏನು ಇಲ್ವಾ. ಡ್ರೈವರ್ ಓರಲ್ ನಾವು ಓರಲ್ ಎಲ್ಲರಿಗೂ ಹೇಳಿದೀನಿ. ಸಿ ಮೆಡಿಕಲ್ ರೆಕಾರ್ಡ್ಸ್ ಏನು ಸಿ ರೋಡ್ ಹಂಪ್ ಒಳಗೆ ಇರ್ಲಿ ಸರ್. ಚಾರ್ಜ್ ಶೀಟ್ ಈಸ್ ಅಗೇನ್ಸ್ಟ್ ಯು. ಆಯ್ತು ನೋಡಿ, ಮಂಡೇವರೆಗೆ ನಿಮ್ ಟೈಮ್ ಕೊಟ್ಟಿದ್ದು. Otherwise, I'll assure you that we are going to increase the compensation. Third, partly, the heard learned counsel for appellant partly. Further hearing by Monday. Next week, Monday na next week. Next week ಅಂದ್ರೆ Monday next week ಆಗಲ್ವಾ? ಆಯ್ತು 26 ಕೊಡಿ. ನೋಡಿ ವಕೀಲರ ಥಿಂಕ್ ಆಫ್ ಇಟ್. ನೀವು ಕಾರ್ಪೊರೇಷನ್ ನಿಮ್ಮ ಲಾ ಆಫೀಸರ್ ಇರ್ತಾರೆ. ನಿಮ್ ಲಾ ಆಫೀಸರ್ ಇರ್ತಾರೆ, ಅವ್ರಿಗೂ ಗೊತ್ತಾಗುತ್ತೆ. ಅಂಡ್ ಯು ಶುಡ್ ಅಡ್ವೈಸ್ ದೆಮ್. ಅಲ್ಲ, ತಿರುಗಿ ಬೌನ್ಸ್ ಆಗುತ್ತೆ ಅಂತ ಹೇಳಿದ್ರೆ ಮುಂಚೆ ವಿಚಾರ ಮಾಡ್ತಾರೆ.
ಚೇತನ್ BL ಸಂತೋಷ್
ಹಾಕ್ಬೇಕಾ ಚೇಂಬರ್ಗೆ?
Let him take this. On merits.
30 ಚೇತನ್
ನೋಟಿಸ್ ಆಗಲ್ಲ ಇದು.
ಇವಾಗನೇ ಅಡ್ಮಿಷನ್ ಬಂದಿದೆ ಅಷ್ಟೇ.
Notice. Number 2. United India. United India.
United India.
You are for United India. Shankar Reddy alla. He is directed to take notice for respondent number 2 insurance company. The learned counsel for appellant is directed to serve the copies on learned counsel for respondent number 2. Appellant R1 into ಸದ್ಯಕ್ಕೆ ಕೊಟ್ಟಿಲ್ಲ ನೋಡೋಣ ಡಿಬೇಟ್ liability is first and respond number 2 ನಿಮ್ಯಾಗ liability ಹಾಕಿದ್ದಾರೆ ಚೆಕ್ ಮಾಡಿ ನೋಡ್ಕೊಡ್ರಿ ಯಾರು ಚೇತನ್ ಅಂಡ್ BL ಸಂತೋಷ್ ಅಂತ ಇದ್ದಾರೆ ನೋಡಿ please the matter after 2 weeks.
Payments are not the brother and authorized of the registry. Bachelor has taken 9,000 income per month.
Date of accident to 23/4/2017.
Okay, supplier notice and earning is 20%. But
Tribunal ಎಷ್ಟು ತಗೊಂಡಿದ್ದಾರೆ 9,000
10,500 as per the
2,000 accident to 2017 11,000 ಇದೆ. Okay.
And allowed Bachelor has rejected 50% since more was a bachelor at the time of accident, age about 29 years. By submission note, the brothers who are the younger and the deceased at the time of accident were 90, one brother 80, another brother 33. Both are depending upon the income of the deceased. And as per the latest decision of Honorable Appellate Court, major sons are also entitled for the compensation under the head of loss of dependence.
Sir, that is not an issue. Loss of dependency ಇಲ್ಲದೆ ಇದ್ರು loss of estate ಒಳಗೆ ಬಂದೇ ಬರುತ್ತೆ ಅದು. Either of the way, ಎರಡು calculation same ಇದೆ. That is not an issue. They are the major brothers. Both are major brothers.
All earning money.
Whether they are not, they are dependents on, what is the age of the deceased?
29 years.
29 years. He was bachelor.
He was a bachelor.
One is 21 years and another is 19 and 23.
They are not at
They are dependents on respond number 4, the appellant number 4. Father is there.
Father is aged about 63 years. What best can he can done at the time of accident?
What was the avocation?
But he was a supplier noted.
Allah, what is the avocation of father then?
Father avocation has not been
Okay. What is the evidence you are led to show that they are dependent?
the one, the evidence of the one. He has clearly stated that all the claimants are depending upon the income.
See, ಅದಕ್ಕೆ ನಾನು ಕೇಳ್ತಾ ಇದ್ದೀನಿ. All claimants are dependent is a one line statement is unwarranted. They are the major brothers.
The cross-examination by the insurance company permitted to their own their suggestion is not permitted to be ಮೂರನೇ ಅರ್ಜಿದಾರರಿಗೆ ಅಪಘಾತ ಸಮಯದಲ್ಲಿ 18 ವರ್ಷಕ್ಕಿಂತ ಜಾಸ್ತಿ ಪ್ರಾಯ ಆಗಿತ್ತು ಎಂದರೆ ಸರಿಯಲ್ಲ. ಆತ ಶಾಲೆಗೆ ಹೋಗುತ್ತಿಲ್ಲ. ಆತನ ಪ್ರಾಯ ಎಷ್ಟು ಆಗಿದೆ ಎನ್ನುವುದು ಶಾಲೆಯಿಂದ ದಾಖಲಾತಿ ಎನ್ನುವುದು ಪರಿಶೀಲಿಸುತ್ತದೆ. ಅಪಘಾತ ಸಮಯದಲ್ಲಿ ಮೂರನೇ ಅರ್ಜಿದಾರರಿಗೆ 18 ವರ್ಷಕ್ಕಿಂತ ಜಾಸ್ತಿ ವಯಸ್ಸಾದ ಎರಡನೇ ಅರ್ಜಿದಾರರು ಕೆಲಸ ಮಾಡುತ್ತಿಲ್ಲ. ಆ ಸಮಯದಲ್ಲಿ ಎರಡನೇ ಅರ್ಜಿದಾರರು ಶಾಲೆಗೆ ಹೋಗುತ್ತಿಲ್ಲ. ಈ ಬಗ್ಗೆ 2 ಮತ್ತು 3ನೇ ಅರ್ಜಿದಾರರು ಶಾಲೆಗೆ ಹೋಗುತ್ತಿಲ್ಲ.
ಅವ್ರದ್ದು ignorance ಬಿಟ್ಬಿಡಿ. ನಿಮ್ಗೊಂದೇ ಕೇಳ್ತೀನಿ. You are even in the cross examination, you are asserting that they are attending the college or school. Where is the document?
Document may not, the age
I'm
of
simply asking you.
the age of the
See what I'm not worried about those. I will consider it. Adar ಬಗ್ಗೆ ಹೇಳ್ತಾ ಇಲ್ಲ. You are specifically asserting.
But my number condition, age of the claimants, self proved not, they are not non-earning members.
No.
Yes, when they were studying.
Sir, question is, if they are studying, there should be a document. If you produce the document, absolutely your argument is bound to be accepted because they are studying, they are non-earning members. Where is that document?
18 years at the time of.
ಅಲ್ಲ 18 years majority ಇರಲಿ. ಪ್ರಶ್ನೆ ಬರೋದು, if they are not attending the school, then they cannot be, it is deemed that they are attending some coolie work.
That cannot be presumed. That cannot be presumed.
It also cannot be inferred that they are dependents.
So, payments are major. But in the present case, they are married and earning.
Sir, they are the class 1 heirs. Sons, major sons or daughters, they become class 1 heirs of the deceased. Here, brothers does not fall under the category of class 1 heirs.
Considering the section for definition of legal representative under section 2, subclause 11, as provided under the CPC, or the Honorable Apex Court has held, they are legal representative and they are entitled for, not entitled, largely they are dependent upon the deceased. Though they are major and earning members.
Sir, whether brother is a legal representative?
Yes, sir, that is what I know.
Sir, ನಾನು ಕೇಳಿ ಅರ್ಥ ಮಾಡ್ಕೊಳ್ರಿ ಪ್ರಶ್ನೆ. ಅಲ್ಲಲ್ಲ. Yes. ವಕೀಲ್ರೆ, ಪ್ಲೀಸ್. ವಕೀಲ್ರೆ, ಮೇಂಟೈನ್ ವಾಟ್ ಅವ್ರು ಹೇಳಿ, ಮೇಂಟೈನ್ ಸಮ್ ಡೆಕೋರಮ್ ಅಷ್ಟೇ. ಒಂದ್ ನಿಮಿಷ.
Section 211 of CPC Court, the Honorable Apex Court has really considered that the brothers are also legal representatives. Not entirely, but largely they are dependent upon the deceased. That is not held in Tara.
ಒಂದ್ ನಿಮಿಷ. You are relying.
Definition for.
Section 211 of CPC. Legal representative who is in law represents the estate of the deceased and includes any person who intermeddles with the estate of the deceased.
And where a party sues or is sued, we are representative.
Character.
Person of.
Whether now I'll come to a legal question. We'll consider dependency. That is on legal representative is different. Dependency is different. Whether in presence of class 1 heirs, the brother being a class 2 heir, can he become legal heir?
He may not be become class 1 legal heir.
But I am not asking class 1 or class 2. I am simply asking you a simple question. In presence of class 1 heirs, we're not concerned about dependency and other things. In case of class 1 heirs, because mother and father are class 1 heirs. Father doesn't even fall under class 1 heir, but he is can be treated as a dependent looking to age. But the brother does not fall under the category of class 1 heir. Mother is there. So the brothers doesn't come under the class of legal representative in general terms. Do you admit it? Now the issue will be dependency. Whether they are dependent, to what extent they are dependent is required to be considered. Other
My
ಬಗ್ಗೆ
suggestion is, instead of deducting 50%, considering the age of the claimants, what the
ಅಲ್ರಿ ನೀವು ಒಂದು ಅವ್ರ ಸ್ಕೂಲ್ ಸರ್ಟಿಫಿಕೇಟ್ ಸ್ಟಡಿ ಸರ್ಟಿಫಿಕೇಟ್ ಹಾಜರು ಮಾಡಿದ್ರೆ ಮುಗಿದು ಹೋಗಿತ್ತಲ್ಲ. You don't want to do it. Why adverse inference should not be drawn against you?
Yes, because not adverse inference cannot be drawn, not considering the age, not.
See, we're not concerned about. I'm asking you, when you specifically assert, I'm using the word assertion, that they are attending the schools. You're 100% sure that they're attending the school, but you don't want to produce any document regarding their school and you withheld it. What the law presumes, adverse inference is required to be drawn in normal course, unless you lead any other cogent evidence regarding disability and other things. See, ಈ citation in what context you are relying?
Page 360. The legal representative. The legal representative of the deceased, no application for compensation by virtue of clause C of section 161. The major married son who is also earning and not fully dependent on the deceased to be still covered by the expression legal representative of the deceased. This court in 2024 expounded that liability to take compensation under the act not cease because of the absence of dependency of the legal representative. Notably, the expression legal representative has not been defined in the act. So, in terms of clause, point number 11, saying what the section in clause 11 has been extracted.
Yes.
And after considering what the honorable court held, so as per the since we have not produced any document to show they are students, in this case, they are the earning members and married. Assume for a moment, yes, they are earning members. Even as per this decision, they are dependent. Therefore, my humble submission.
Sir, here there is no reference of dependency, it is reference of legal representation.
After considering what.
See, one thing, in case of a son, though he is a earning member, he will be entitled for estate of the deceased, and the estate will be quantified in view of the compensation. Sir, adra ಬಗ್ಗೆ ಎಲ್ಲ decision clarify ಮಾಡಿದ್ದಾರೆ. Loss of estate and loss of dependency can be worked out in the same manner ಅಂತ ಹೇಳ್ತಾರೆ. There is no issue, because now that is also not a serious issue, that a major son is not entitled, only ನಾನು consortium ಕೊಡ್ತೀನಿ ಅನ್ನಕ್ ಬರಲ್ಲ, because the moment a person dies, the compensation will be quantified looking to the number of dependents. Once it is quantified, it becomes the estate of the deceased, alva. Then estate, when it becomes estate of the deceased, automatically legal heirs, class 1 illegal heirs first will be entitled. In the absence of class 1 legal heirs, class 2 legal heirs will automatically in. That is law.
So far as class 1 legal heirs, class 2 legal heirs, strictly may not be made applicable to this one, for as motor vehicle accident claim is concerned.
No, it depends on the dependency. I do consider it depends on the dependency. Dependency means the other things will have to be considered. ಅದಕ್ಕೆ ನಾನು ನಿಮ್ಗೆ ಕೇಳ್ತಾ ಇದ್ದೀನಿ, ನೀವೆಲ್ಲ ಹೇಳಿದಿರಿ ಇಷ್ಟು ಆರ್ಗ್ಯುಮೆಂಟ್, ಒಂದು ಸ್ಕೂಲ್ ಸರ್ಟಿಫಿಕೇಟ್ ಹಾಜರು ಮಾಡಲಿಲ್ಲ.
Oh, no, they have not produced anything. But even assume for a moment they are earning member, then also not they have to be
No,
considered.
then this citation will not help you. This citation, they are the class 1 heirs being the legal representatives.
No, they are the brothers here. Brothers, they are the brothers. The claimants are the brothers of the deceased, not class 1 heirs. In this case, they are the brothers. Finally, come to para 2, page number 359. The claim petition was filed by the respondent number 1 and 2 hearing, who are the major sons of Srimati Anari Devi.
Sir, brothers ಅಲ್ಲ ಅವರು, ಅದಕ್ಕೆ ಹೇಳ್ತಾ ಇದ್ದೀನಿ ನಾನು, they are the sons. You are twisting the facts. Brothers different ಆಗ್ತಾರ, sons differ ಆಗ್ತಾರ. Son will inherit, become a class 1 heir. Brother will not become a class 1 heir. You are ignoring this. You are asserting that they are brothers. Here it is not a case of brothers. It is a case of son, major sons. In that event, again, the compensation is to be quantified, even though they are not dependents. They are entitled for under the loss of head estate, which is the compensation arrived. That will become estate for the sons. That is the law laid down in this case. Yes, the income was taken on lower side. Future prospect. What is his age? 29 years, Allah. So 40%. No. Let him complete. 40% future prospects. Consortium ಕೊಟ್ಟಿದ್ದಾರೆ. Consortium. Love and affection, now that has gone. Allah. Even that can be replaced with the consortium. So again, appellant 1 and 4 are entitled for consortium. One can be adjusted, other 40,000 on ಬರುತ್ತೆ ನಿಮಗೆ, because brothers does not fall under the head of any consortium. Filial ಬರಲ್ಲ, parental ಬರಲ್ಲ, spousal consortium ಮೂರುದ್ರೊಳಗೂ ಬರಲ್ಲ. ಸತ್ವಿಂದರ್ ಕ್ಲಿಯರ್ ಇದೆ, ಮ್ಯಾಗ್ಮುಕ್ ಕ್ಲಿಯರ್ ಇದೆ. ಹೌದಾ? So 40,000 is additional. Income 11,000 ಆಗ್ಬೇಕು. And according to you, 50%, in place of 50% deduction, 1/3 is to be taken. Sorry. Yes. ಹೇಳಿ. ಅಲ್ಲ ನಿಮ್ಗೆ ಅಡ್ಮಿಟೆಡ್ ಫ್ಯಾಕ್ಟ್ಸ್ ಕೇಳ್ಬಿಡ್ತೀನಿ ಮೊದಲು. ಕನ್ಸೋರ್ಟಿಯಮ್ ಒಂದೇ ಕೊಟ್ಟಿದ್ದಾರೆ, ಲಾಸ್ ಆಫ್ ಎಸ್ಟೇಟ್ ಇದನ್ನ ಕೊಟ್ಟಿದ್ದಾರೆ ಅವರು. ಲವ್ ಅಂಡ್ ಅಫೆಕ್ಷನ್ ದಟ್ ಮೇ ನಾಟ್ ಬಿ ಪ್ರಾಪರ್, ಇಟ್ ಶುಡ್ ಬಿ ಟ್ರೀಟೆಡ್ ಆಸ್ ಕನ್ಸೋರ್ಟಿಯಮ್. But one more consortium towards to the extent of 40,000 is required to be paid as per Satvinder Kaur. 40,000 ಕೊಟ್ಟಿದ್ದಾರೆ ಅವರು. ಪೇರೆಂಟ್ಸ್ ಹಿಡಿದ್ರೆ ಇಬ್ರು ಇದ್ದಾರೆ, ತಂದೆ ತಾಯಿ. ಅಲ್ಲ they will come to
17 has to be age is 29 years. Come to 70. And lower court also taken 40% cheaper. 8,000 add money. 7,000 add money.
ಅಷ್ಟೇ 11,000 ತಗೊಳಕ್ there is now it is settled law.
Has to 50% has to be retained. Criminal also held is 40%. And all these should be
ಕನ್ಸೋರ್ಟಿಯಂ ಹೇಳಿಲ್ಲ ನೀವು. ಅದನ್ನೇ ಕೇಳಿದೆ ನಾನು ನಿಮ್ಗೆ. ಬಿಕಾಸ್ ಓನ್ಲಿ 40,000 ಕೊಟ್ಟಿದ್ದಾರೆ, ಇನ್ನ 40,000 ಕೊಡ್ಬೇಕಾಗತ್ತೆ.
When in case of death of bachelor, depending upon each circumstance of the case, what the court can consider and
100% ಸರಿ, always.
Specifically mentioned.
When you are relying a citation, you should be prepared with that citation. You cannot expect that court should go on searching it. ಎಲ್ಲ ಸ್ಟ್ಯಾಂಡರ್ಡ್ ಸೈಟೇಷನ್ ಇದನ್ನ ಮಾಡಿಲ್ಲ.
That's why I'm saying guidelines of that one they are followed. That's why I'm saying that judgment. The Lordship number 21, they are quoted the same judgment. That's why
He wants to enlighten.
That's why I'm saying that. ಅದನ್ನ enlighten ಮಾಡಿದ್ದಾರೆ 21 ಅಲ್ಲಿ. 21. ಅದಕ್ಕೆ ನಾನು ಹೇಳಿದ್ದೆ
2009 AC ಜೊತೆಗೆ 1298. Yes, what you have to say? That has been considered elaborately in Saravarma edition. Siblings normally, include father cannot be treated as a dependent of the other.
Merely because he's a bachelor, cannot be a ground to this meeting. But they want
Saravarma ಒಳಗೆ ಇದನ್ನು observe ಮಾಡಿದ್ದಾರೆ, when there is a father, the minor siblings will be normally dependent on father unless contrary evidence is led. Now, what is the contrary evidence? You will have to lead. You cannot ask the other side. So now you will have to lead a positive evidence that they are school going brothers. That was not there. ನೀವು ಅದನ್ನು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ರಿ ಅಂದ್ರೆ ಆಟೋಮೆಟಿಕ್ಲಿ ಕಾಂಟ್ರರಿ ಇಸ್ ಪ್ರೂವ್ಡ್ ಅಂತ ಆಗುತ್ತೆ. ಈಗ ಮಾಡ್ಬೇಕಾಗಿತ್ತಲ್ಲ. ವಾಟ್ ಪ್ರಾಬ್ಲಮ್ ಇಸ್ ಎವ್ರಿಥಿಂಗ್ ಇಸ್ ಡನ್ ಇನ್ ದಿ ಹೈಕೋರ್ಟ್ ಓನ್ಲಿ. ಅಪೀಲ್ ಒಳಗೆಲ್ಲ ನೀವು ಆಲ್ ಪಾಸಿಬಲ್ ತಗೊಳ್ತೀರಿ. ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಒಳಗೆ ದೇ ಕ್ಯಾಶುಯಲಿ ಪ್ರಾಸಿಕ್ಯೂಟ್ ದಿ ಮ್ಯಾಟರ್. This is a factual aspect, including insurance company also. All possible defense ಅವ್ರು ಇಲ್ಲೇ ಬಂದು ರೇಸ್ ಮಾಡ್ತಾರೆ. ಇಲ್ಲೇ ಬಂದು ಡಿಎಲ್ ಇರ್ಲಿಲ್ಲ, ಅದು ಪಾಲಿಸಿ ಕಂಡೀಷನ್ಸ್ ವೈಲೇಷನ್, ಅಲ್ಲಿ ಎಲ್ಲ ಕ್ಲಾಸ್ ಒಳಗೆ ಒಂದು ವರ್ಡ್ ಮಾಡೋಣ ನಾವು.
FCC ಇದೆ ನಾನು. FCC ಇದೆ.
What is the age of the deceased? The 22 ಅಂತ ಹೇಳಿ ತಗೊಂಡಿದ್ದಾರೆ.
Petition also 29. But down and any problem I don't know. 22 years ಅಂತ ಇದೆ ನೋಡಿ ಇದ್ರೊಳಗೆ. Petition ನೋಡಿ 29 years. Medical records 29 years. All medical records 29.
This is an appeal filed by the appellant's claimants under section 173 subclause 1 of MU Act, challenging judgment and award passed in MUC number 753 of 2017 on the file of MSAT Udupi sitting at Kundapur, dated 19th February 2019, so far as it relates to quantum of the award. For the sake of convenience, parties herein are referred to the original ranks occupied by them before the tribunal. The brief factual matrix leading to the case are that on 23/4/2017 at 7 AM, deceased Mahesh was standing on the eastern side of the road on NH 66, opposite to Guru Prasad apartment, Gundmi village of Udupi Taluka. At that time, the bus bearing KA 51 bar D2507, driven by its driver in a rash and negligent manner and dashed against the deceased. As a result, he suffered fatal injuries and immediately he was shifted to Government Hospital, Udupi, and thereafter Penlock Hospital, Mangalore, and during the course of the treatment, he succumbed because of the injuries on 25/4/2017. The petitioners have spent more than rupees 1 lakh towards funeral treatment and funeral expenses, and the deceased was aged about 29 years and earning rupees 20,000 per month. The claimants claim to be the dependents have filed a claim petition under section 166 of any act, claiming compensation of rupees 26,75,000 from respondents 1 and 2. The respondents 1 and 2, respondent number 1 did not appear before the tribunal and contested the matter, while respondent number 2, insurer, filed objections denying the allegations and assertions made thereunder. It is contended that the compensation claim is exorbitant, speculative, and without any basis. And further, it is asserted that driver of the offending vehicle was not possessing valid and effective driving license as on the date of the accident. It is further asserted that there is a breach of policy conditions and hence he dispute his liability. The tribunal, after appreciating the oral as well as documentary evidence, has awarded a total compensation of rupees 14,30,800 with interest at the rate of 6% per annum. Being aggrieved by the being dissatisfied with the quantum of the award, the claimants have approached this court seeking enhancement, heard the arguments advanced by the learned counsel for appellant and learned counsel for respondent number 2, insurer. Peruse the records. The learned counsel for appellant would contend that the deceased was working as a supplier and was earning rupees 20,000 per month, but the tribunal has taken notional income at 9,000, which is on lower side. He would further contend that no proper compensation was awarded under the head of loss of consortium, and further he would specifically harp on the fact that the deduction was made to the extent of 1/2 on account of deceased being bachelor, but considering the dependency, the tribunal ought to have deducted only 1/3 towards the personal expenses. Hence, he would also contend that future prospects were not awarded. Hence, ನಿಮ್ದು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿದ್ರಿ, ತಗೊಂಡಿದ್ದಾರೆ, ಅದನ್ನ ತಗೊಂಡಿದ್ದಾರೆ, ನೀವು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿದ್ರಿ ಫ್ಯೂಚರ್ ಪ್ರಾಸ್ಪೆಕ್ಟ್ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಹೇಳಿ. ಮತ್ತೆ ಅದಕ್ಕೆ ನನ್ನ ಅದನ್ನ hence he would seek for enhancement of the compensation. Per contra, the learned counsel for respondent number 2 submit that the tribunal has erred in taking multiplier 18 in place of 17, as age of the deceased was admittedly 29 years. He would also contend that 40% future prospects were taken note of and 50% was rightly deducted as per the decision of the Sarla Varnama case. He would contend that in the absence of any contrary evidence, deduction cannot be taken to the extent of 1/3, as the brothers cannot be treated as dependents. Hence, he would seek for dismissal of the appeal. Having heard the arguments and perusing the records, there is no serious dispute of the fact that the deceased met with an accident on 23/4/2017 at 7 a.m. and subsequently he succumbed because of the accidental injuries on 25/4/2017. The tribunal has held that the accident is because of actionable negligence on the part of the driver of the offending vehicle and fastened the liability on insurer, and this finding is not challenged. Now, the only issue is regarding the quantum. The tribunal has taken the income of the deceased at 9,000. All along it is asserted that deceased was working as a supplier in a hotel and earning rupees 20,000. However, there is no evidence led to substantiate this aspect, and in the absence of any material evidence, the tribunal has taken the notional income at 9,000 per month. This court, and admittedly, the accident has occurred in the year 2017. This court is consistently taking the income, notional income at 11,000 in respect of the accidents occurred in the year 2017. Hence, the tribunal has erred in taking the income on lower side. At the same time, though there is a specific assertion in the petition and as well as in the appeal memo that the deceased was aged about 29 years, which is also supported by the PM report.
For the ration card exhibit P10, as per the ration card, it's age was about 22 years. That is what the tribunal has taken 22 years.
What is the PM report?
PM report, as per the instruction, they will note, this is the document note.
Are you disputing what is your assertion in the claim petition? Sir, nim claim petition ಬಗ್ಗೆ ಕೇಳ್ತಾ ಇದ್ದೀನಿ ನಾನು. See, you cannot write two horses. Claim petition ಒಳಗೆ ಒಂದು pleading ಮಾಡಿ ನನ್ನ ಡಾಕ್ಯುಮೆಂಟ್ ಬೇರೆ ಇದೆ ರೀ, ಅದ್ರ ಪ್ರಕಾರ ತಗೊಳ್ರಿ ಅನ್ನಕ್ ಬರಲ್ಲ. See, that is not the criteria, sir. ನೀವು assertion ಮಾಡಿದ್ರಿ, ಗೊತ್ತಿಲ್ಲ ಅಂತ ಹೇಗೆ ಹೇಳ್ತೀರಾ? You assert that he is attended the school. Ration card is not a document to disclose the age. School certificate, living certificate hazard madidira. School living certificate hazard madidira, things would have been different.
Including one certificate, not copy of report.
And very interestingly, you have produced the Aadhaar card of claimants 2 and 3, appellants 2 and 3, not about deceased. Why? Date will be there in the Aadhaar card. ಅದಕ್ಕೆ ಹೇಳ್ತಾ ಇದ್ದೀನಿ ಸರ್, ನೀವು ಎಲ್ಲ ಇಲ್ಲ ಆರ್ಗ್ಯುಮೆಂಟ್ಸ್ you take all defense. I'm not finding fault with you, but those were not attended before the tribunal while prosecuting the matter. ಅಲ್ಲಿ ಮಾಡೋಲ್ಲ ಎಲ್ಲ. ಕ್ಲೇಮಂಟ್ಸ್ ಎಲ್ಲರದು ಅಪೆಲೆಂಟ್ ಕ್ಲೇಮಂಟ್ಸ್ ಆಧಾರ್ ಕಾರ್ಡ್ ಹಾಕಿದ್ರಿ ಎಕ್ಸೆಪ್ಟ್ ಡಿಸೀಸ್ಡ್. ಅದ್ರೊಳಗೆ ಏಜ್ ಬಂದೇ ಬರುತ್ತಲ್ಲ. ನಿಮ್ ಇದನ್ ತಗೊಂಡ್ರ ರೇಷನ್ ಕಾರ್ಡ್. There is another elder brother. ನಿಮ್ ಡಾಕ್ಯುಮೆಂಟ್ ಹೇಳುತ್ತೆ ರವಿ.
Not a claimant.
He is not a claimant. He is elder to the deceased. ಇದೆ ಇಲ್ಲಿ ನಿಮ್ದೇ ಡಾಕ್ಯುಮೆಂಟ್. Exhibit P10 on which you are relying. When there is another elder brother, and if this is taken into consideration, the father is not crossed 50, 60 also. Father has not crossed 60. In 2014, his age is shown as 56 years. Extent is in 2017. So he would be 59 only. You have shown his age as 63.
One number.
Sixty-one ಹೇಗೆ ಆಗ್ತಾನೆ? As on the date of accident, he was less than 60 years, not a senior citizen. Sir, ಏನು ಮಾಡ್ತಿದ್ದಾರೆ? Any postal, any material document evidence. The learned counsel for appellant has invited the attention of the court to exhibit P10, which is a copy of the ration card, wherein age of the deceased was shown to be 18 years as on 29/9/2014. And on the basis of this document, it is contended that as on the date of the accident, he was aged about 22 years. But the PM report speaks a different story. Even otherwise, in the petition itself, all along it is alleged that deceased was aged about 29 years, and it is supported by other medical evidence. Under these circumstances, the tribunal has erred in taking the age of the deceased as 22 years and wrongly applied multiplier 18. If the age of the deceased is taken as 29 years, multiplier 17 is required to be applied. Next. The tribunal has deducted 50% of the 50% of the income of the deceased towards personal expenses, basing on the decision of the Sarala Verma, reported in 2009 ACJ 1298. The learned counsel in this context, learned counsel for appellant in this context has placed reliance on a decision reported in 2020 part 11 SCC page 356, National Insurance versus Birendra and others. But it was pertaining to death of a mother and claimants being the major and earning children. Hence, in the instant case, the claimants, appellants 1 and 4 are the parents, but appellants 2 and 3 are the brothers. The tribunal has held that they cannot be treated as dependents. The learned counsel for appellant would contend that the appellants, the appellant number 2 and 3 are depending on the deceased as they are attending the school. In this regard, he has invited the attention of the court towards cross-examination of PW1. However, PW1 in her cross-examination specifically asserted that both appellants 2 and 3 were attending the school. In that event, nothing prevented the appellants from producing material document to show that they are the students so as to claim them as dependents. Apart from that, Exhibit P10 itself disclosed that the another brother Ravi is also there, and under such circumstances, when there is another elder brother Ravi who is aged about 36 years as on the date of accident, the deceased, the appellants 2 and 3 cannot be termed as a dependence on deceased. Further, this issue has been elaborately discussed in the decision of Sarala Verma, and it is observed that even the father cannot be treated as a dependent, and only the mother can be treated as a dependent. Hence, considering the analogy, the law is laid down that in normal courses, in case of bachelor, deduction should be 50% with certain exceptions. But the appellants have not placed any material evidence to show that they are falling under any exceptions. Under these circumstances, the contention of the learned counsel for appellant that deduction should be 1/3 in place of half cannot be accepted, and the tribunal has rightly deducted half of the income towards personal expenses of the deceased. Next. The tribunal has awarded rupees 40,000 under the head of loss of love and affection, which is not permissible. However, it can be treated under the head of consortium. But however, since there are two parents are there, each of them is entitled for 40%, 40,000 each, as per the edition reported in Magmano Pranashiti Bharatam and Satvinder Kaur. Considering the income of the deceased as 11,000, and after adding 40% towards future prospect, the loss of dependency would work out as under 40%.
40% less ಮಾಡಿದ್ರೆ 1,600 into 12 into 17. 40% ಡಿಡಕ್ಟ್ ಮಾಡಿದೀನಿ.
ಡಿಡಕ್ಟ್ ಅಲ್ರಿ, ಆಡ್ ಆಗಬೇಕು. ಡಿಡಕ್ಟ್ ಹೆಂಗ್ ಮಾಡ್ತೀರಾ? 11,000 plus 40 by 100, 15,400. Correct. The 15,400 into 17 into 12 into divided by half, 50%. ಎಷ್ಟು ಆಗುತ್ತೆ ನೋಡಿ. Further, the claimants are entitled for, claimants appellants are entitled for 15,000 each under the head of loss of estate and funeral expenses. Further, appellants 1 and 4 are entitled for 40,000 each under the head of parental consortium, and as such, the claimants appellants would be entitled for total compensation of rupees so and so under following heads: loss of dependency, estate, general expenses, consortium 80,000. The tribunal has awarded rupees 14,30,800 and hence the appeal needs to be allowed in part and accordingly proceed to pass the fine. Appeal is allowed in part. The claimants, appellants are held entitled for total compensation of so and so as against 14,30,800 awarded by the tribunal. The announced compensation shall carry interest at the rate of 6% per annum from the date of petition. The respondent number 2 insurer is directed to deposit the entire enhanced compensation with accrued interest thereon within 6 weeks from today. The out of enhanced compensation, the appellant number 1 is entitled for 70% and appellant number 4 is entitled for balance 30%. The deposit and disbursement shall be as per the terms of the award.
Appeal number 30.
Janardhan Reddy. ಕೃಷ್ಣಮೂರ್ತಿ ಅವರು ಇದ್ದಾರೆ ಸರ್. ಕಿರಣ್ ರೋನ್, well, that is there. ಇದ್ದಾರೆ ಅವರು ಹೋದ್ರು. ಅವ್ರು ಜೂನಿಯರ್ ಸರ್ಟಿಫಿಕೇಟ್ ಬರ್ತಾರಲ್ಲ,
ಅದ್ರ ಬದಲು ಅವ್ರು ಇನ್ನೊಂದು
ಒಕ್ಕಲಕ್ಕೆ ಯಾರು ಅಲ್ಲ ಹಾಕಿದ್ರಲ್ಲ, ವಿಲ್ ಕನ್ಸಿಡರ್ ಇಟ್. ವಿ ಕ್ಯಾನಾಟ್ ಡೈರೆಕ್ಟ್ ಹಿಮ್.
36 my lord.
34 sir.
Sorry.
Sorry, 32. Sorry, 32.
30. Sorry, 33 ನಂದು. Sorry.
32. ಅಲ್ರಿ, ಇವ್ರು ಕಿರಣ್ ರೋನ್ ಹೆಸರು ಹೇಗೆ ತೋರಿಸಿದ್ದಾರೆ? ಆನ್ ವಾಟ್ ಬೇಸಿಸ್? ಅಲ್ರಿ, ಇದ್ರಲ್ಲಿ ಅವ್ರ ವಕಾಲತಿ ಇಲ್ಲಲ್ಲ. How can it be shown, sir? Illa. Savita, Sophia is there. Rishika, Sharath is there. Amogha, Varsha is there. ಅವ್ರು ಇದ್ದಾರೆ.
ಕಿರಣ್ ವೀರಾನ್
And even Our retire, it is the duty of the insurance company to engage a different counsel. It is an institution. Now insurance company.
National insurance.
National yaar idhar hai.
My lord, I will take notice and I will inform them, my lord.
Notice, sir. Huh?
Although I think earlier, my lord, earlier advocate has been elevated, my lord, to this.
ಅಲ್ಲ ಎಲಿವೇಟ್ ಆದ್ಮೇಲೆ ಅವ್ರ
Yes.
ಜೂನಿಯರ್ ಹೆಸರು ತೋರಿಸಿದ್ದಾರೆ, that is wrong
Yes.
because even he is not there, he has not a
I will
significant
inform the
ವಕಾಲತ್
company.
also.
I will inform the company, my lord.
ನಾನು ಈಗ ಫಾರ್ ಟೆಂಟೇಟಿವ್ಲಿ ನಿಮ್ಗೆ ಹೇಳ್ತೀನಿ ನೋಟಿಸ್ ತಗೊಳ್ಳಿಕ್ಕೆ, you can
Yes,
take note.
Yes.
See, Hegde Mulkund is directed to take notice for respondent number 2 in MFS 3713 of 2019 and appellant in MFA 3910. Is the matter after 2 weeks.
All right. My lord, a claimant's appeal for enhancement and liability involvement of the vehicle and other things are not in dispute. It is only
But-
for enhancement.
ಅಲ್ಲ ಡೆತ್ ಇಂಜುರಿ ಕೇಸ್ or ಡೆತ್ ಕೇಸ್
Injury. ಬರ್ತೇನೆ ಸ್ವಾಮಿ, one by one. I will.
ಮೆನ್ಷನ್ ಮಾಡ್ಲಿಲ್ಲ ಅವರು.
Reddy is there, it seems.
ರೆಡಿ ಇಸ್ ದೇ ಅವ್ರು ಇದ್ದಾರೆ.
My lord, date of accident is 3/1/2017.
Yes.
My lord, appellant was aged 43 years, working as a housekeeper and maid servant. My lord, claims to be earning by housekeeping and maid servant 14,000, 8,000 plus 6,000 ಅಂತ ಹೇಳ್ತಾರೆ. My lord, the injury sustained is, my lord, severe head injury, pontine hemorrhage. My lord, this word pontine hemorrhage is important. My lord, pontine hemorrhage is a very serious head injury, and surviving this percentage is also 40 to 50%. My lord, due to which, my lord, she was treated in 2 different hospitals, Sakra Hospital and Nagarjuna Hospital, Mysuru, for totally 13 days. My lord, according to Dr. Miller, and also medical opinion, my lord, PW4 is the doctor, neurosurgeon.
Yes.
My lord, the total subsisting disability is 38%. 38%. The appellant was aged 43 years, a lady. My lord, first, my lord, I want to draw my lord's attention regarding the doctor's evidence PW4. PW4.
Yes, sir.
But I have been working as a consultant neurosurgeon at BGS Global Hospital, so and so, so and so. Is a second pair. She was treated at Sakra Hospital and so date. History of road traffic, followed which she sustained injury to head, face and left leg for traumatic brain injury. CT scan brain done, then shows head injury with pontine hemorrhage. But pontine hemorrhage is pertains to brain injury. It's a brain injury. Treated conservatively in NSICU. On 7/1/17, shifted to Narayana Hospital, Mysuru for continued treatment and monitoring. She was kept under observation, discharged on 16/1/2000. She was evaluated on 24/6/2018 at our center and found to have history of generalized weakness. Lord, may kindly see giddiness, memory disturbances, and gait disturbances. On examination, she was conscious, obeying commands. She had gait ataxia. Lord, further, I have examined her for outpatient department. So, difficulty noted by the doctor is she has difficulty to walk, feels imbalance and always she has sense of falling without support. She has a difficulty in making day-to-day decision, reasoning and judgment. She has a reduced daytime alertness and require supervision of daytime activities. She has difficulty in speech. She will require assistance while walking on elevation. Kindly note this word. She will require assistance while walking on elevation. Her memory is considerably reduced. She has undergone neuropsychological assessment, cognitive disability, ability, so and so, so and so. May I continue, Mala? Or directly can I come to the last para, seventh para? 38%. A permanent whole body disability, 38%, according to guidelines published in textbook of so and so, so and so. Well, so, due to this one-time hemorrhage, well, if we log into Google, it will the meaning of this word is available, and by going through these medical texts, well, the doctor has assessed the disability and the seriousness of the injury is to be looked into, my lord. Well, she is aged, as I stated, 43 years. Extent is 2017, 11,000 idu takolbeku, income takolbeku, 9,000 takolide. If I correct 2017, it seems 2017, it is 11,000. 11,000. Well, as far as disability aspect is concerned,
Yes.
in the absence of any rebuttal evidence, well, since it is a severe head injury case, even doctor said it is a 38%, but associate the disabilities she is now suffering, because even without assistance of another person, she can't move. Well, actually, it is a case of 100% occupational disability, that is functional disability. But I am not insisting to consider it as 100%. But 13% disability consideration without giving any proper reason and adopting the theory of 1/3. Well, that is a neuro in the by rejecting the PW4 doctor neurosurgeon's evidence. Well, it seems to be not proper.
Whether PW4 is a treated doctor?
Treated doctor is totally irrelevant because he is a
Whether he is a treated doctor?
No. Treated,
So
treated,
now, okay, now he has given certain disability, certain discomforts faced by the claimant. But that is not noticed in her evidence itself.
Well, that is not important, my lord, because, my lord, it's a case of head injury.
You are not catch up the point. What I am. She was examined before the court.
Yes, examination is
there is no difficulty. Observation regarding all these, which a doctor has now stated.
I'll have it next week, my lord.
Because of the reference, evidence.
ಅದಕ್ಕೆ ಹೆಡ್ ಇಂಜುರಿ ಕೇಸಲ್ಲಿ ಸ್ವಾಮಿ ನೋಡ್ಲಿಕ್ಕೆ ಸರಿ ಕಾಣ್ತಾರೆ, ಆದ್ರೆ ನೋಡ್ಲಿಕ್ಕೆ ಸರಿ ಕಾಣ್ತಾರೆ. ಇವರು ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಡ್ವೊಕೇಟ್ಸ್ ಅವ್ರನ್ನ ಅಫಿಡವಿಟ್ ಹಾಕಿ ಎವಿಡೆನ್ಸ್ ಮಾಡಿಸ್ಬಿಡ್ತಾರೆ.
So affidavit better because affidavit I do consider it will not be advocate will prepare, but the cross examination is to be taken into consideration. Cross examination, she answered normally. There is no demeanor recorded by the tribunal that she is taking some time, she is facing any imbalance. ಏನು ಅಬ್ಸರ್ವೇಷನ್ ಇಲ್ಲ. ಅದನ್ನೆಲ್ಲ ನಿಮ್ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ವಕೀಲರು ಮಾಡ್ಬೇಕಾಗಿತ್ತಲ್ಲ.
ಮಾಡ್ಲಿಲ್ಲ. ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಹಾಕೊಳ್ಳಿ ಸರ್.
ಯಾರು? PW4 is not a neurosurgeon.
Is a neurosurgeon. I have been working as a consultant neurosurgeon. Second paradalla ಇದೆ. Well, my humble request is, well, the appellant now approached the High Court, being dissatisfied with these finding of the tribunal regarding quantification. ಏನಲ್ಲಿ ಇದೇ ಹೇಳುವುದಕ್ಕೆ ಹೆಚ್ಚು ಗೌರವ ಕೊಡಬೇಕು ಹೊರತು ಏನಿಲ್ಲ ಹೇಳೋದಕ್ಕೆ ಕೊಟ್ರೆ ಸ್ವಲ್ಪ ಕಷ್ಟ ಆಗ್ತದೆ ಸ್ವಾಮಿ ನಮ್ಗೆ.
ಅಲ್ಲಲ್ಲ ನಾನು ಇಲ್ಲ
ಯಾಕಂದ್ರೆ
ಅನ್ನೋದಕ್ಕೆ ಕೇಳಿ-
ರಿಬಟಲ್ ಈಗ ಅವರು
ನಾನು ಏನಿದೆ ಅದನ್ನೇ ನೋಡ್ತಾ ಇದೀವಿ ನಾವು.
ನೋಡಿ
ಇಲ್ಲೂ
ಸ್ವಾಮಿ.
ಹುಡುಕ್ತಾ ಇಲ್ಲ ನಾವು.
ಅಲ್ಲ ಇಲ್ಲ ಈಗ ಡಾಕ್ಟರ್ ಎವಿಡೆನ್ಸ್ ಅದಕ್ಕೆ ರಿಬಟಲ್ ಎವಿಡೆನ್ಸ್ ಏನು ಇಲ್ಲ. PW 2 and 3 produced all the medical records. Appellate kindly gone through the medical records, which are reveals the present situation of the appellant. How serious injury these are. Pontine hemorrhage. Appellate, what is the meaning of pontine hemorrhage? That is to be looked into.
What's the income?
11,000 ನಂತರ ಆಗಬೇಕು. That he has also canvassed. There is no issue about it.
One submission, what is the medical this textbook says about this injury? When the injury to the pons is complete, the patient may pass away. If a patient with complete injury survives, he or she could develop locked in syndrome. In this syndrome, the person has no sensory or motor function except for the ability to move their eyes up and down. Some people can also blink. It is the medical.
It is medical, sir, but that was not brought on record, sir.
Sir, that is I do admit. That is the
When see, going to Google, searching things, it defines, but that should be brought on record. The evidence has to be placed on record. And she was cross-examined before the tribunal. And she was quite natural as per her evidence. She was perfectly answered all the questions.
ಅಲ್ಲ ಅದು ಬರೋದಿಲ್ಲ ಸ್ವಾಮಿ. ನಾ ಹೇಳೋದು ಕೇಳ್ಕೊಳ್ಳಿ. ಏನಂದ್ರೆ ಈಗ ಫಂಕ್ಷನಿಂಗ್ ಆಫ್ ದಿಸ್ ಬ್ರೈನ್ ಈಸ್ ಪಾರ್ಟ್. ದೇರ್ ಆರ್ ಸೆವರಲ್ ಪಾರ್ಟ್ಸ್. ಕೆಲವು ಸಲ ಕೇಳಿದ ಪ್ರಶ್ನೆಗೆ ಇಮಿಡಿಯೇಟ್ ಉತ್ತರ ಕೊಡ್ಲಿಕ್ಕೆ ಲೇಟ್ ಆಗ್ಬಹುದು. ಕೆಲವು ಸಲ ಯಾವುದೋ ಒಂದು ಪರ್ಟಿಕ್ಯುಲರ್ ಫಂಕ್ಷನ್ ಕಡಿಮೆ ಆಗ್ಬಹುದು. ಈಗ ಅವ್ರು ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಕೇಳಿದ ಪ್ರಶ್ನೆಗೆ ಉತ್ತರ ಕೊಡ್ಲಿಕ್ಕೆ ಆಗೋದಿಲ್ಲ ಹೇಳೋ ಪರಿಸ್ಥಿತಿ ಈ ಹೆಡ್ ಇಂಜುರಿಯಿಂದ ಆಗೋದಿಲ್ಲ.
Loss of memory ಇದ್ದಾಗ she will not be in a
No, there is
position to answer all the questions promptly.
ಅಲ್ಲ, ಲಾಸ್ ಆಫ್ ಮೆಮರಿ
As stated in her petition only, denying all the relevant suggestions made by the other side.
ಇಲ್ಲೇ ನಾ ಹೇಳ್ತಾ ಇರೋದು, ಇಲ್ಲೇ ಸ್ವಾಮಿ ನೋಡ್ತಾ ಇರೋದು. ಅಲ್ಲಿ ಎದುರ್ನ ಆತರ ನೀವ್ ಹೇಳಿದ್ ನವ್ನಿ ಇಲ್ಲ. ಲಾಸ್ ಆಫ್ ಮೆಮರಿ ಪವರ್ ಇಲ್ವೇ ಇಲ್ಲ ಅವಳಿಗೆ. ಲಾಸ್ ಆಫ್ ಮೆಮರಿ ಪವರ್ ಇಲ್ಲ. ಬ್ರೇನ್ ಇಂಜುರಿ ಟು ಬ್ರೇನ್ ನೆಸೆಸರ್ಲಿ ಟು ಬಿ ಎಂಡೆಡ್ ಇನ್ ಲಾಸ್ ಆಫ್ ಮೆಮರಿ. ವಾಟ್ ಈಸ್ ದ ಡಿಸಬಿಲಿಟಿ? ವಾಟ್ ಈಸ್ ಸಿ ಡಿಲೇಡ್ ಕಮಾಂಡ್ and she has get ataxia. Witness box ಅಲ್ಲಿ ನಿಂತ್ಕೊಂಡಿದ್ದಾಗ ಅಟಾಕ್ಸಿಯಾ ಗೊತ್ತಾಗೋದಿಲ್ಲ. ಹೆಂಗ್ ಗೊತ್ತಾಗ್ತದೆ
ಸರ್? ನಿಮ್ದು ಡಾಕ್ಟರಿ ಎವಿಡೆನ್ಸ್ ನೋಡಿ, ಪ್ಯಾರಾ ನಂಬರ್ 4 clause F. He states that her memory is considerably reduced.
Yes,
that means loss of memory only. Memory is reduced.
Yes, to disprove the same. See, he is a neurosurgeon. The surgeon is a neurosurgeon. Ordinary adana ಏನು ಹೇಳೋದಿಲ್ಲಾಗಿತ್ತು. ಇವರು ಇದನ್ನ ಸುಳ್ಳು ಅಂತ ತೋರಿಸಲಿಕ್ಕೆ ರಿಬಟಲ್ ಎವಿಡೆನ್ಸ್ ಏನಿದೆ 37% ಅಂತ ಅವ್ರು ಹೇಳ್ತಾರೆ. ಅದಕ್ಕೆ ಏನಿದೆ ರಿಬಟಲ್ ಎವಿಡೆನ್ಸ್ ಏನಿದೆ? ಮತ್ತೆ ಎಲಾಬರೇಟ್ ಆಗಿ ಹೇಳ್ತಾರೆ ವಾಟ್ ಇಸ್ ದ ಎಫೆಕ್ಟ್ ಆಫ್ ದಿಸ್ ಹೆಡ್ ಇಂಜುರಿ, ಅದರ್ ಥಿಂಗ್ಸ್. That is why my respectful submission is consideration of 38% disability, even though it may not sufficient, but it should be considered 38%, not 13%. She is a manual labor, and the injury itself shows pontine hemorrhage. Pontine hemorrhage is a very serious thing.
And pontine hemorrhage regularly, but PW4 did not disclose what will be the consequences of this injury. He simply says, and now you are highlighting that the chances of survival was very minimum, 50% chances. Everything is okay. Now she has survived. There is no issue about it.
It is all already proved fact. That is, even though the doctor not said, ಇದೆಲ್ಲ ನಾವು ತಿಳ್ಕೊಂಡು ಪಾಂಟೈನ್ ಹೆಮರೇಜ್ ವಾಟ್ ಇಸ್ ದ ಮೀನಿಂಗ್ ಆಫ್ ಅವನ್ ಪಾಂಟೈನ್ ಹೆಮರೇಜ್ ಇಷ್ಟೇ ಹೇಳ್ತಾನೆ. ವಾಟ್ ಇಸ್ ದ ಮೀನಿಂಗ್ ಆಫ್ ಪಾಂಟೈನ್ ಹೆಮರೇಜ್?
He is a expert.
Yes.
He is a specialized
That is,
person.
yes, yes, yes.
It is your duty to extract what is the effect of that.
That
He
is
did not do so.
ಓಕೆ ಸ್ವಾಮಿ ನಾ ಕೋರ್ಟ್ ಸಂತಿ ಜಗಳ ಮಾಡ್ಕೊಳ್ಳೋದಿಲ್ಲ ಯಾವಾಗ
ಅಲ್ಲ, ಜಗಳ ಅಲ್ಲ ಸರ್, ಜಗಳ ಅಲ್ಲ ಇದು.
ನೋ
It's question of jagala. See, ultimately we are here to see that a just compensation is awarded.
my experience with the bench from 32 years is always we have to try to convince the bench. Otherwise
ಅಲ್ಲ sir,
convince the bench.
at the same time it is our also duty. ನಮ್ಗೆ ಏನೇ doubt ಬಂದ್ರೆ we will pose it to you because you will be in a position to answer, counter it.
Yes,
If I simply hear you without posing my doubts, tomorrow you will feel that had the court has posed this question, I would have clarified until ನಿಮ್ ತಲೆಯಲ್ಲಿ ಬರಬಾರ್ದು.
ಹೌದು ಕರೆಕ್ಟ್ ಗೊತ್ತಿದೆ ಸ್ವಾಮಿ. ಈ ಲೈನ್ ಆಫ್ ಇದಿದೆ ಪ್ರಾಕ್ಟೀಸ್ ಮೆಲಾಡ್. Further, my respectful submission is, my lord is required to be considered the functional disability as 38%, because and the less minimum and the 38% tagಬೇಕು. ಯಾಕಂದ್ರೆ the injury really reveals her functioning ability is and aching this following lucrative activities is adversely affected. ನೋಡಿ ಇಂಬ್ಯಾಲೆನ್ಸ್ ಅಂತ ಹೇಳ್ತಾರೆ. ಇಂಬ್ಯಾಲೆನ್ಸಿಂಗ್ ಬಾಕ್ಸ್ ಅನ್ನು ಇಟ್ಕೊಂಡಿದ್ದಾಗ ಗೊತ್ತಾಗತ್ತಲ್ಲ. ಹೆಂಗ್ ಗೊತ್ತಾಗತ್ತೆ ಸ್ವಾಮಿ ಇಂಬ್ಯಾಲೆನ್ಸಿಂಗ್? ಹೆಂಗ್ ಗೊತ್ತಾಗ್ತದೆ? ಡಾಕ್ಟರ್ ಹೇಳಿದ್ರೆ ಮಾತ್ರ. ಈಗ ಅವ್ಳು ನಿಂತ್ಕೊಂಡು ಹಿಂಗೆ ಮಾಡ್ಲಿಕ್ಕೆ ಆಗೋದಿಲ್ಲ ಬಾಕ್ಸ್ ಅಲ್ಲಿ. ಮತ್ತೆ ಅಷ್ಟೆಲ್ಲ ಅವಶ್ಯಕತೆನೂ ಇರೋದಿಲ್ಲ. ಬಿಕಾಸ್ ಶಿ ಈಸ್ a lady having poor knowledge and labor, housekeeping and ಯಾವುದೋ ಒಂದು ಈಗ ವೈಟ್ ಕಾಲರ್ ಜಾಬ್ ಆದ್ರೂ ಪ್ರಶ್ನೆ ಬೇರೆ. ಇಟ್ ಈಸ್ ಮೆಲಡ್ as according to me, I tried to convince my lord.
Yes. No, I did not find fault with you, sir. It is your duty to get the maximum compensation to the client. You won't find fault with it.
ಯಾಕಂದ್ರೆ ನಮ್ಗೆ ಹೈಕೋರ್ಟ್ ಪ್ರಾಕ್ಟೀಸಿಂಗ್ ಅಡ್ವೊಕೇಟ್ಸ್ ಗೆ 90% ಜನರಿಗೆ ಯಾವ್ದು ಇಂಟ್ರೆಸ್ಟ್ ಇರೋದಿಲ್ಲ. ನಾವು ಬರ್ತದೆ ನಾವು ಮಾಡಿ ಕಳಿಸ್ತಾ ಇರ್ತೀವಿ. Because money is a deposit, compensation amount depositing before the trial court. We are only 1,500 or 3,000 rupees.
But in spite of that, all the possible defenses will be canvassed in the High Court, which ought to have been done before the tribunal itself during the course of the trial only. Trial ಒಳಗೆ ಮಾಡೋದೆಲ್ಲ
ಗ್ರೌಂಡ್ ರಿಯಾಲಿಟಿ ಅಲ್ಲ, ಗ್ರೌಂಡ್ ರಿಯಾಲಿಟಿ ಬಹಳ.
ನೀವೇನ್ ಎಫರ್ಟ್ ಮಾಡ್ತೀರಿ ಅದ್ರದ್ದು ಒಂದು 50% ಎಫರ್ಟ್ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಒಳಗೆ ಆದ್ರೆ things would have been different. It becomes very easy ಅಲ್ಲ.
ಬಹಳ ಸಂತೋಷ ಸ್ವಾಮಿ. ನನಗೆ ಇಂಡೈರೆಕ್ಟ್ ಆಗಿ ನೀವು ಹೊಗಳಿದ್ದಕ್ಕೆ, ಐ ಆಮ್ ಡೂಯಿಂಗ್ ಮೈ ಡ್ಯೂಟಿ ಅಂತ ಹೇಳಿದ್ದಕ್ಕೆ ಐ ಆಮ್ ವೆರಿ ಹ್ಯಾಪಿ. ಎನಿವೇ ಮೆಲಡ್, these severe head injury case, ಮೆಲಡ್, these keeping in mind the occupation and the doctor evidence and in the absence of rebuttal evidence, ಅವ್ರು ಏನಾದ್ರು ಮಾಡಬಹುದಿತ್ತು ಇದನ್ನ. because to rebut this medical opinion ಅವ್ರು ಏನು ಮಾಡಿಲ್ಲ. According to me, it's a case of the disability is required to be considered more than the actual disability as per Rajkumar's case. But I am praying and insisting this honorable court at least considering 38% whole body disability. It is my humble request. Pain and suffering amenities is ಸ್ವಲ್ಪ ಜಾಸ್ತಿ ಮಾಡೋದು. 1,57,658 the medical bills. I have no grievance on that. Loss of earning for the laid up period ಕೊಟ್ಟಿಲ್ಲ ಸ್ವಾಮಿ. Loss of earning for the laid up period and future medical expenses ಕೊಟ್ಟಿಲ್ಲ. She required medication throughout her life. ಒಂದು ಅಮೌಂಟ್, ಯಾವುದೋ ಒಂದು ಗೌರವಾನ್ವಿತ ಅಮೌಂಟ್. ಅದರಿಂದ ನನಗೆ ಇರೋದೊಂದು ಮೂರೇ ಇದು ಹೊರತು ಬೇರೆ ಯಾವುದೂ ಇಲ್ಲ. May I repeat, Melad? May I repeat?
Yes.
One is loss of earning for the laid up period ಕೊಟ್ಟಿಲ್ಲ. And while calculating future loss, consideration of 9,000 instead of 11,000. And disability main is 13%.
Your main RP is disability. You are concentrating on mainly on disability. It should be minimum 38 to 39% in place of 13%.
13%. And income 9,000 instead of
Income he admits.
Ah.
Income, there is no
Amele-
issue about it.
Amele-
Because he fairly submit that income can be taken at 11,000.
ಆಮೇಲೆ ಇದಕ್ಕೆ ಎಮ್ಯುನಿಟೀಸ್ ಗೆ ಸಿನ್ಸ್ ಇಟ್ ದ ಕೇಸ್ ಆಫ್ ಹೆಡ್ ಇಂಜುರಿ 25,000 seems to be lower side. Some amount is required to be added. And future medical expenses. The doctor evidence shows Malad she required medication throughout her life. That is
Yes.
a one Gauravan with one amount. Ashte.
Yes. Yes, sir.
As disability is concerned, the fact is that the stated that there is a disability of fatigue. That is so, one kind has to be considered. 30%.
But one thing is, the disability is not to any particular limb, so as to treat it one third. This is a disability to the controlling organ of the entire body, human
Yes,
body,
yes,
stand on that organ itself.
Yes.
Hello, correct, whole body. It affects entire body. If the bone stops working, automatically entire body, all organs may be intact, but they cannot work. Huh?
Yes, analysis is, but I'm very happy by the analysis of my lord.
Yes.
But it is 15% instead of 30.
Yes.
Whereas loss of income during later period, individual has not avoided. We must income. Amenities hotel are 25% has been avoided.
ಅಲ್ಲ ಕೊಟ್ಟಿದ್ದಾರೆ
ಅಲ್ಲಿ
ಸ್ವಲ್ಪ
ಕೊಟ್ಟಿದ್ದಾರೆ ಲೋವರ್ ಸೈಡ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ ಅವರು. ಸೊ ಕನ್ಸಿಡರಿಂಗ್ ದಿ ನೇಚರ್ ಆಫ್ ಇಂಜುರಿ ಇಟ್ ಅಪಿಯರ್ಸ್ ಟು ಬಿ ಆನ್ ಲೋವರ್ ಸೈಡ್, ಎನ್ಹಾನ್ಸ್ ಮಾಡ್ರಿ ಅಂತ ಕೇಳ್ತಾ ಇದ್ದಾರೆ ಅವರು ಅಷ್ಟೇ. So according to you, 15% it can disability can be taken at 15%. Loss of income for the income can be taken at 11,000 in place of 9,000, and 3 months laid up period can be granted. These are your contentions. Third, reserve.
ರಿಸರ್ವ್ ಸ್ವಾಮಿ
Reserved.
ಆಗ್ಲಿ ಒಂದಾರು ಸಿಕ್ತು. ನಿನ್ನೆ 4:45 ವೇಟ್ ಮಾಡಿ ಏನು ಇಲ್ದೆ ಹೋಗಿದ್ದೆ.
ಅದಕ್ಕೆ ವೇಟ್ ಮಾಡಂತ ಹೇಳಿದೆ ಸ್ವಾಮಿ ನಿಮಗೆ.
Number 34, P.G. Ravishankar Shastri.
Connected appeal may not have excluded.
And the insurance company is coming on the basis of liability. Okay. Yes, okay. Documents, ಅದೇ ಬಂದಿದ್ದಾವೆ. What is the date of accident as per the case of the claimant? 13/13. 15.
Yes.
R1 ಎಲ್ಲಿದೆ? B1 in R1. Yes.
Intimation. This is the Indian hospital. Standard. The also reason action is written. Right, lot of accident. Incident. RPA. Right of money. Self call is not right now. All from right patient was generated. And within bracket sameness as per the letter provided by the patient party. Initially. Was incident self call. Subsequently, is
Yes.
all from right patient was 300. Even the second document is R3. Emergency department for report. So that complaints can call from right. So R3. The next page,
R3 na?
R3.
R3 is part of discharge alba.
Oh, emergency department report R3.
R3 11 R1 R2 ಆದ್ಮೇಲೆ R2 ಇಲ್ಲ ಒಮ್ಮೆ R4 ಬರುತ್ತೆ. R4 ಇದೆ R5 R6
Third pages of E24 and 11 pages.
Okay. E24 and 4.
ಅದನ್ನೇ ಕೇಳಿದೆ ನಾನು PC ಅದಕ್ಕೆ ಕೇಳಿದೆ ನಾನು. ಪೇಜ್ ನಂಬರ್ ಪೇಜ್ ಅಲ್ಲ P20 ಪೇಜ್ ನಂಬರ್ ಇದು ಅದರ ಪೇಜ್ ನಂಬರ್ ಎಷ್ಟು ನೀವು ರಿಲೈ ಮಾಡ್ತಿದ್ದೆ ಯಾವ್ದು ಅಲ್ಲ ಇರ್ಲಿ ನಾ ಅಪ್ರಿಶಿಯೇಟ್ ಮಾಡ್ಬೇಕಾದ್ರೆ ಇಲ್ಲಿ ಬೇಕಲ್ಲ, ನಮ್ಮಲ್ಲಿ ಬೇಕಲ್ಲ ಒರಿಜಿನಲ್. Even pages of R24, P24 and 60 and for our R3. Yes, okay, ಹೇಳಿ.
Self call from vehicle type. The emergency department report also. The portion of the complaints, self call from vehicle.
Yes.
And the next one was which are marked is the putting of the patient and receive the patient from ambulance to the then with the complaints of self call from vehicle. The 15th of December 2016 on observation patient is conscious and oriented. Right. So what happens is that after that the complaint is lost. Stating that he was a clean rider. Instead of a rider, he becomes a clean rider. This is another substance.
So according to you, he has shifted his position, rider to pillion rider.
The evidence is also went in this behalf. That the complaint in page number 18 of the judgment. Complaint marked by one says that what he was riding another motorcycle and the bike which met with an accident 450 and because of there was a curvature road, not control the vehicle and met with an accident. The rider does not sustain any injuries. That's what is the statement. The rider does not sustain any injuries,
But the minute when it sustains injury, and is taken to the hospital. The reasoning of the tribunal, in page 18, I read now 6 lines. The complainant came to the complainant can be considered as a bystander and no human assistance. Says because the bystander. Bystander means according to me who's on the spot. Here says he was riding on another motorcycle. He doesn't fit into the definition of a bystander also. Therefore, all this the value of the complaint, FIR and charge sheet not come to the head of the complaint because it is all an afterthought in management with the insured to saddle the liability of insurer and to make a number of claims. The documents would speak for themselves that it is a self-fault. As is oriented and conscious at the first moment, though let's say which is the airship that he was unconscious only for 10 minutes. And he is also accompanied to the hospital by the rider. And then one of the cross-examination says that I was accompanied with the G1 complainant and the rider. They do not mention the motorcycle number or who's the rider. Nothing is come for. On this ground, I am seeking for allowing of my appeal and dismissing it here. And they all say that Rajesh, who is owner of the motorcycle, is a cousin brother. And they all decide not their own vicinity, and it is a one of the story with the byproducts and substance. Sunny, whose the rider is brother-in-law. That is not the mission words in cross-examination.
Yes.
Yes, say that. Yes, very short movement. This was specifically stated in the reference.
Yes.
That suffered individually far from the of his own house. Good, this was specifically stated in the reference. Basically, the airport stating that there was indirect had sustained into a regular accident. The effect of evidence on doctor will see how do not appear to have mentioned to the university airport. Basically, did not place reliance on the doctor as well as injured. Second, that it did not know what was written in the document and the signature was taken on one page. This approval known of the fact that the doctor did not take a signature on a piece of paper mentioning something which is incorrect. If our establishes beyond the shadow of doubt that the injury sustained was not on account of a vehicular accident, that being so, the university and the airport not justified in making me award lot of the university and airport set aside. So this is not where in the first instance, the statement is made, they would not make any wrong entry in the UNC or the discharge summary. What is stated by the attendant or by the injured himself or is stated in the UNC. Later on, in this case, they have never tried to say that once there was a clear right, not the permission because first instance, the statement is made that it was not rider and the self. This is what the issues most well. Here, most thought and justice word together.
Yes.
Whether we may not be injury made in the medical record is not pursuant to the issues the involvement of the or not. As considered by my friend.
He has raised one issue. The rider who claims he did not suffer any injury, he himself admitted the injury to the hospital. I do not know.
He was taken to the hospital through ambulance and one G1 gives the complaint. That is on record, that MAG observes it.
Why he has not accompanied him?
He says, my lord, he was not able to.
Why he has not suffered any injury? He has caused it. See, these are the issues. These are questions will automatically arise. He has not accompanied, according to you. The rider of the motorcycle did not accompany him.
To the hospital.
Hmm.
He is not there.
Hello, now I am asking you whether it is there or not. Whether he,
Not there on record. That he has accompanied or not.
then who has taken him?
He was ambulance was called and he was shifted.
Who has accompanied him to the hospital? Because there is a reference of a bystander. Who is that bystander?
He was riding a motorcycle, mainly G1.
He is the bystander.
Yes.
That is I'm asking. He's the rider has shifted him to the hospital. It may be ambulance or auto, whatever it may be. Anything, let it be. So rider himself has shifted him to the hospital. Yes.
So far as this aspect is concerned, MAG is detailed from para 10 onwards, analyze evidence. Mainly the evidence based by the claimant, that is not all these records from the which starts from wound certificate. It says due to RTA, then there was a police investigation. IME report was drawn. It shows a damage was injury. Then after inquiry, police charge sheet against rider of the motorcycle. And by appreciating these aspects, these police records weighs more for this reason. So the only minority document is the claimant an entry made in the medical record showing that is an fault. Admittedly, claimant the BW2 says, doctor of the hospital who treated the patient, claimant says the claimant was unconscious.
But document says a different aspect. He was conscious and oriented.
That was an entry made by one Rashmi who was she was not examined. Doctor who has treated and who has tendered evidence says he was unconscious for 10 minutes. Then he was jumping from the bed and he was not oriented. That was the condition of the claimant. And there was a severe head injury and left side paralysis. Rashmi, kindly see this aspect. Injury caused is serious head injury, which caused paralysis, left side and paralysis claimant. That is it. May I take for a moment PW2 evidence unit para. It will be the issue is PW2. Dr. Elvis Rodriguez. Para 111. I saw the picture for this.
1 minute. Yes.
I saw the picture for this first time on 2015 at about 38. At that time, Vishal was unconscious and left side paralyzed.
CT scan of head showed bleeding from right side. He was observed in the one period. He gradually recovered. However, he continued to have left-sided weakness. He was extremely restless and agitated and trying to jump from the bed. As the psychiatric opinion is taken on patient accordingly, he was discharged on 5 months. Then he became conscious, but continued to have left-side paralysis. Then, my lord, regarding the entry, one Rashmi, staff of Indiana Hospital, has tried to discharge somewhere. If we were not aware of history of accident, then we write far from bike. But what was stated by PWP is, if they are not aware of the history of the accident, they write it as far from bike. And such entry was made by one Rashmi. But she was not examined or to the averment made in the medical records. Own certificate does not reflect the type of accident. On the date of accident, petitioner was unconscious. This is the evidence of.
But this doctor has examined him at 10:30 a.m.
Yes.
But the accident has occurred at 6:30 a.m. after 4 hours.
Necessarily, my lord, taking from the place of accident to Bangalore hospital, my lord, it will have its own time, my lord. That is, at the time of my lord, his inspection, he was unconscious.
But what was the fate of the witness when he was admitted in the hospital?
Lord, that was, my lord, the medical record speaks, my lord. Admission at the time of admission, my lord.
At the time of admission, it is reported that he was conscious.
And my lord, the MACT, my lord, also observes that the entry as a fall from bike, that aspect is not proved by the respondents, my lord, by rendering any evidence. On the other hand, the evidence rendered by the claimant coupled with the evidence of doctor and my lord shows that the accident has occurred as asserted by the claimant. Page 11 of the MACT judgment, my lord. Page 11 of the MACT judgment speaks, my lord, a consideration of exhibit R1 to R5 and says, no doubt the initial medical records indicate that the Isha had his alcohol, but the complainant has stated in his complaint has stated that the rider and Indian rider was injured by overtaking vehicle and he had called an ambulance unlawfully and admittedly injured Isha to Indiana Hospital. The complaint can be considered as the bystander and there is no inconsistency. The discrepancy in the initial medical record of is the rider of the motorcycle has admitted that he fine. So these are the findings, my lord. The complaint was made by Jeevan. He had called the ambulance and sent the injured to the hospital, my lord.
What history has given?
RTA.
RTA.
Yes.
He was the rider of the vehicle.
He was not the rider. Jeevan was the rider. My lord, Jeevan had given the complaint, my lord, who was a bystander. Sandeep was the rider.
Sandeep was the rider. Siva was a bystander.
Sandeep was the rider. Therefore, my
Rider
lord,
did not sustain any injuries.
not necessary. Not necessary. My lord, he rides his bike with the rash and negligent manner. My lord, unable to control the bike. Indian rider was
See,
and
I'm not disputing those aspects. That is one thing correct too. The rider did not sustain any injury.
yes, sir.
Normal cause, he would accompany the injured.
My lord, accident happens, my lord, by a spur of moment. How the consciousness of the rider prevails, my lord, nobody can, my lord, say. On the other hand, judge observes, my lord, he was not able to speak in the statement given by
See,
Jeevan.
there is one observation that the history was given by the bystander. Who is that bystander?
The Jeevan.
Jeevan.
Yes.
Whether he is examined,
it was not examined. No, the author who has written that it's self-fault.
See, the author is one aspect. Question is, the person who bystander has shifted the injured to the hospital, he has given in history. The same was reduced into writing. Neither the author is examined or nor the informant is examined. The rider is Sharath, Sandeep.
Yes. Complainant is Jeevan.
Sandeep is rider. Yes.
Therefore, I may respect the subject matter. Non-examination of the person Rashmi, who had written on the medical record as self-fault. It's a pattern to the defense of the injured.
Simultaneously, non-examination of informant.
So far as that aspect is concerned, I may respectfully submit. The claimant has to do the accident and rational negligent driving and ignorant ponderance of probabilities of the case. Here, on the basis of complaint given by Jeevan, the police conducts inquiry, FIR was filed, and a charge sheet was filed.
Merely because a charge sheet is filed, that cannot be taken. That is now settled law. That is to be independently proved.
Independently, I may respect it. The state and the medical record state that it is self-fault. Unless the person who has written that self-fault.
That was a document relied by you. See, to rebut the entries, why you ask the other side to disprove the end contents? It is your document. Then you should have examined the Jeevan, isn't it?
I may respectfully submit non-examination of the Jeevan is not fatal. On the other hand, non-examination of the Rashmi is made entry in the medical record by the insurance company. To prove that such entry was made by her on the information of Jeevan, started with the case of the insurance company.
Yes. One, let him complete. He has not yet completed. That is one regarding liability. The other.
Quantum, I have we had a left side damage accident. Therefore, my award of compensation on pain and opinion 40,000 per side. And who was working in the oil factory, like woman, my lord, and drawing revenue. Whereas NACP is 50,000 in spite of production of evidence, not cases at all, but we will not examine.
So you are not harping much on salary. You are harping on pain and suffering. Disability, how much disability was taken?
Doctor has not stated that the disability was not taken. Doctor says there is a left side paralysis, but disability is not.
Yes. Yes. Yes.
Informed me And I was brought to Indian hospital by him and given. Persons accompanied the injured, that is, big as well as given. Everyone is. Indian hospital. Evidence. Other one.
That is Dr. Mahabalesh Shetty. Yes.
As stated, cell phone from bike. You are conscious that you can injury. We can history has stated the Sharad. First we write history in the agency and then the education. This would not go right. What is the statement of Sharad? Cell phone. Based on this statement, the is already in this.
But you are not cross-examined him. RW1 and cross madlilla. A simple suggestion. It is true that Sharath had a head injury. That's the only cross-examination. He has given information. Everything he has stated. That portion was not cross-examined. That is not denied. ಅದಕ್ಕೆ ಆಲ್ವೇಸ್ ಹೇಳ್ತೀನಿ ನೀವು ಏನು ಇಷ್ಟು ಎಫರ್ಟ್ ಮಾಡ್ತೀರಾ ಇಲ್ಲಿ ಅಷ್ಟದ್ರದ್ದು 50% ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಮಾಡಿದ್ರೆ ಬಟ್ ಈವನ್ ದೇ ದಿಸ್ RW1 is also from medical same hospital. ಅದೇ ಒಂದೇ ಒಂದು ಸೆಂಟೆನ್ಸ್ ಇದೆ ಅದೇ ಹೇಳಿದ್ದೇನೆ ಒಂದು ಸೆಂಟೆನ್ಸ್ ಇದೆ ಅದು ಅಷ್ಟೇ ಅದಕ್ಕೆ ಹೇಳ್ತಾ ಇರೋದು ನಾನು ರೆಗ್ಯುಲರ್ ಹೇಳ್ತೀನಿ ನೀವೇನು ಇಷ್ಟು ಕಷ್ಟಪಟ್ಟು ಎಫರ್ಟ್ ಮಾಡ್ತೀರಿ ಅದ್ರದ್ದು ಒಂದ್ ಸ್ವಲ್ಪ ಪರ್ಸೆಂಟ್ ಕೆಳಗೆ ಮಾಡಿದ್ರೆ ಎಷ್ಟೋ ಎಲ್ಲ ಅಸಿಸ್ಟೆನ್ಸ್ ಸಿಗುತ್ತೆ ಈವನ್ ಕೋರ್ಟ್ ಬಿಕಾಸ್ ಪ್ರಾಪರ್ ಎವಿಡೆನ್ಸ್ ಇದ್ರೆ ಇಟ್ ಬಿಕಮ್ಸ್ ಈಸಿ ಫಾರ್ ಕೋರ್ಟ್ ಆಲ್ಸೋ. Third reserve. ನಿಮಗೆ ಹಿಯರಿಂಗ್ ಮಾಡಿದ್ದು ನೋಟ್ಸ್ ಇಲ್ಲ ಅವ್ರ ಮಿಸ್ ಆಗಿಬಿಟ್ಟು ಆರ್ಡರ್ಸ್ ಪೋಸ್ಟ್ ಡಿಕ್ಟೇಟ್ ಆಮೇಲೆ ಕೊಡ್ತೀನಿ ಅಂತ ಹೇಳಿದಾರಂತೆ ಅದು ನೋಟ್ಸೇ ಇಲ್ಲ ಅದರಲ್ಲಿ ಅವ್ರು ಕೇಳ್ತಾರೆ ಈಗ ಡಿಕ್ಟೇಟ್ ಮಾಡ್ಬೇಕು ನಾನು ಏನ್ ಕೇಳಿದ್ರೆ ಒಂದೇದು ಎರಡನೇದು ಅದ್ರ ನೋಟ್ಸ್ ಇಲ್ಲ ಅಂತ ಇಲ್ಲಿ ಬರ್ದಿದ್ ನೋಟ್ಸ್ ಇಲ್ಲೇ ಇದೆ ಜಸ್ಟ್ ಚೆಕ್ ಮಾಡ್ಬೇಕು
ಆದ್ರೆ ನಾನು ಡೇಟ್ ಬರ್ತಿದ್ದೀನಿ ಕನ್ಫರ್ಮ್ ಮಾಡ್ತೀವಿ
ಕಾಫಿ ಸ್ಟೋನ್ ಕೊಟ್ಟು
ನಿನ್ನೆ
ಕಾಫಿ ಸ್ಟೋನ್
ಸರಿ ಸರಿ ಅದೇನೋ ನಿನ್ನೆದು ಅಂತ ನಮಗ್ ಗೊತ್ತಾಗಲ್ವಲ್ಲಪ್ಪ ಪಾಪ ನಿನ್ನೆದೇನೋ ನೋಟ್ಸ್ ಇಲ್ಲ ಅಂತ ಇದ್ದಾರೆ ಏನ್
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಎಷ್ಟನೇ ನಡೀತಾ ಇದೆ? ಎಷ್ಟನೇ ನಡೀತಾ ಇದೆ? ಕೋರ್ಟ್ ಆಫೀಸರ್ ಎಷ್ಟನೇ ಮ್ಯಾಟರ್ ನಡೀತಾ ಇದೆ?
ಹಲೋ ಸರ್, ಕೇಳ್ಸಲ್ವಾ ಗುರುದೇವ್ ಪ್ರಸಾದ್ ಅವರೇ?
ಇಲ್ಲ, ಕೇಳಿಸ್ತಾ ಇಲ್ಲ.
ಫೈನಲ್ ಇಯರಿಂಗ್ ತಗೋಬೇಕು ಸರ್.
ಹೌದಾ? ನಮ್ಮ 36 ಮ್ಯಾಟ್ರು.
ಅದೇ ಇವಾಗ ಬಹುಶಃ
ಸರಿ ಸರಿ ಸರಿ.
ಹೆಗ್ಡೆ ಮುಲ್ಕಂದ್ ಅವ್ರು ಇದಾರಾ?
ಅವರು ಬರ್ತಾರೆ, ಬರ್ತೀನಿ ಅಂದ್ರು.
ಒಂದ್ ಪಾಸ್ ಓವರ್ ಇದೆ.
ಸಾವಿರ ಆದ್ಮೇಲೆ ನಮ್ದ
ಗೊತ್ತಿಲ್ಲ ಸರ್, ಕೇಳಿ ನೋಡ್ತೀನಿ ಸಾಹೇಬ್ರನ್ನ.
ಆಯ್ತು.
ಅದೆಲ್ಲ ನಿನ್ನೆದು ಪಾಸ್ ಲಿಸ್ಟ್ ಅಂತ ಕೊಡಪ್ಪ ಸಾಹೇಬ್ರದ್ದು. ನಾನು ಅಲ್ಲದೆ ಫೋನ್ ಮಾಡಿ ಕೇಳ್ಕೊಪ್ಪ. ಆಮೇಲೆ ನಾನೇನೋ ಒಂದು ನೋಟ್ಸ್ ಅಂತ ಡಿಕ್ಟೇಷನ್ ಕೊಡ್ಬೇಕಂತ ಸಿಗ್ತಾ ಇಲ್ವಂತೆ ನೋಟ್ಸ್. ನಿನ್ನೆ ಪಾಸ್ ಲಿಸ್ಟ್
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಪಾಸ್ ಓವರ್ ಇದೆಯಾ? ಕೋರ್ಟ್ ಆಫೀಸರ್ ಪಾಸ್ ಓವರ್ ಇದೆಯಾ?
ಮೊನ್ನೆ ಒಂದಿದೆ ಸರ್.
ಓಕೆ.
ನಾವು ಯಾಕೆ ತೆಗ್ದಿಟ್ಟಿಲ್ಲ ಅದಕ್ಕೆ.
ಪಾಸ್ಟ್ ಓವರ್ ಇದೆ, ಸೀರಿಯಲ್ ನಂಬರ್ 24. ಅಶೋಕ್ ಎನ್ ಪಾಟೀಲ್.
My lord, I appear for the appellant, my lord. My lord, I appear for the appellant.
Yes, sir.
appeal of the insurance company, my lord, on the question of quantum.
Only
my
you
lord,
are disputing quantum only.
quantum, negligence, and my lord, interest.
Interest awarded is 9%.
9%, my lord, it is to be 6%. My lord, the income taken was 12,000 rupees. It is lesser, my lord, as per the local chart, my lord.
What is the date of accident?
At page, my lord, 6 of the judgment, my lord, at para 10, my lord.
Allah, what is the date of accident?
Date of the accident is 2017, my lord, on
9/1/17.
9/1/17, my lord.
So 2017 accident. Okay.
But
So
she's a
11,000 should be
11,000 should be the, even if we contend that there was no material, but 11,000 should be the, my lord.
She was doing tailoring work and a skilled worker, doing tailoring work. She's a
There is no
skilled worker.
material.
Therefore, 12,000 rupees is reasonable.
Before that, my lord, I'll submit it and my lord.
Let him complete, sir. Yes, sir.
My lord, your lords may kindly see the reasoning. At paragraph 9, your lords may kindly see, my lord.
Yes.
No, sorry, my lord, paragraph 10, page 6.
Yes.
The deceased was aged of 57 years at the time of accident. He had notarized copy of the Aadhaar card exhibit P10 is exhibited. Therefore, appropriate multiplier is 9. She is a homemaker. In this regard, the Honorable Appellate Court considered 12,000 is the minimum wages of a skilled worker. In the present case, the prisoner does not provide any income proof. In this case, the notional income of the deceased is taken at 12,000 rupees. In so far as the case is concerned, PW1 is the age of 63 years old, senior citizen. At this old age, the husband and wife are depending on each other for their daily activities. Consortium, love and affection. For homemaker, it is a skilled job to maintain home and family. It is appropriate to deduct 1/3 towards the personal expense of the deceased from her income. After deducting 1/3 towards the income of the deceased is taken at 8,000 rupees. Further, my lord, I will read out this one more paragraph. My lord, 8,64,000 has been arrived at under loss of dependency. Further, your lordship may clearly say the love and affection cannot be assessed in terms of money. Business lost the love and affection of the deceased and moral support of his wife. Companionship is more required during his old age. Therefore, towards consortium, it is appropriate to award 1 lakh towards the loss of estate. It is appropriate to award 1 lakh towards 1 lakh. In the absence, the loss of estate 1 lakh. But in the absence of appropriate evidence, funeral and obsequious ceremonies amount to 35,000 is reasonable. Totally, my lord, one is for consortium 1 lakh. 1 lakh for loss of estate, 35,000 has been awarded towards funeral expenses. Totally 2,35,000 has been awarded. Under the conventional letter, my lord, it should be in view of the price in this case. It's only 70,000, my lord.
Yes.
My lord, income, my lord, your lords may kindly appreciate uniformly, my lord, in the absence of any material, my lord, regarding the income. This one 11,000 is the guideline accepted, my lord, in all these cases. So it is to be taken, my lord.
But one thing is that future prospects were not added.
Not added.
Now we calculate, my lord, with my learned friend. My lord, it will amount to 10%, my lord, because the age of the deceased was 57 years.
10% of the future prospects ಎಷ್ಟಾಗುತ್ತೆ?
11,000 ತಗೊಂಡ್ರೆ 1,100 ಆಗುತ್ತೆ.
12,000 ತಗೊಂಡಿದ್ದಾರೆ. Almost I do consider regarding consortium and loss of estate excess ಕೊಟ್ಟಿದ್ದಾರೆ. I do consider it.
Yes, my lord.
But as regards loss of dependency, future prospects added ಮಾಡಿದ್ಮೇಲೆ almost same ಬರುತ್ತೆ.
Further, my lord, further, your lords may kindly see we have taken a specific ground apart from this. That, my lord, this petitioner is the husband and deceased was the wife. He was a pensioner, my lord, not dependent on the income of the deceased. And my lord, he was getting as admitted in the this one, my lord, what is it? His examination chief, 28,000 rupees per month he is earning. So in such circumstances, my lord, only one dependent, my lord, that is only one person, that the prisoner is the husband. And in such circumstances, my lord, either, my lord, loss of dependency may not be considered, or it is to be loss of estate in view of Manavalgan's case, or else, my lord, this 50% can be towards this one, my lord, this one 50% towards the contribution, my lord, it is to be taken, my lord, because only one dependent, even if he is a dependent, instead of 1/3 deduction, 50% should have been deducted, my lord. Morning, your lordship, my lord, read out, my lord, observed in that earlier case, Sarla Verma's case has been, your lordship, referred. In Sarla Verma also speaks about, my lord, if dependent is one, my lord, then, my lord, 50%. So this is the, my lord, interest, my lord, 6% may kindly be appreciated. Further, my lord, we have taken a contention regarding a contributory negligence, my lord. Your lordship may kindly peruse the sketch, my lord. Sketch, my lord, exhibit P5, my lord. Exhibit P5, my lord.
Yes.
But I do not have the sketch with me, my lord, because my file was misplaced and I have taken out this one. But my lord, what the tribunal observes, my lord, your lordship may kindly see from the sketch. The insured vehicle was proceeding on the proper right side of the road. And my lord, this, if I am right, my lord, that that's early morning, 5 o'clock, it is a straight road.
Yes.
And what the tribunal observes is 3/4 of the road she has crossed, and the car dashed against her, my lord. Still, my lord, while attempting to dart across or cross the road, my lord, maximum care is required.
Hello, whatever it may be, one thing is, what was the need for you to move on the extreme wrong side of the road?
Wrong side, my lord. Sorry, my lord. If it is there, my lord, I am not.
It is there because he has moved on the wrong side of the road. The road is sufficiently having sufficient width, and either side there is a service road.
It may be, my lord, a cross road. I think he may be taking right turn. Right turn towards. So I will leave it to my lord regarding this.
Because the total width of the road is about 38 to 40 feet. And the accident is at the age of 32.5 feet.
Yes, my lord.
So
but anyway, my lord, these are all, my lord, your lords may kindly appreciate. The vehicles are running on the, my lord, it is, my lord, no, this zebra crossing was provided. And my lord, it is the common, this one, my lord, that the person while crossing the road, my lord, he must take the for himself. Maximum.
That is one aspect. But at the same time, you are the owner being a driver, he cannot say that it is the botheration of the pedestrian.
No, we are not saying, my lord, we are not, we should not.
And there is no explanation of why the vehicle moved on the wrong side.
My submission is, my lord, if we are seeing the sketch, and in the absence of, my lord, this eyewitness, my lord, my humble submission is, some, I'm not saying that 100% or 50%, I'm not saying, my lord, some percentage of negligence in crossing the road without taking care may kindly be attributed, my humble prayer to this honorable court, my lord.
Yes.
My lord, morning at 5:15, bright sunshine, straight road.
Morning 5:15, bright sunshine will be there.
It will be there, my lord. It will be there. It is in the month of August, I
January,
believe.
sir. In the month of January.
January, Swami. Shankranti hatra baruವಂತ time ಅದು.
ಅಲ್ಲ ಅವಾಗ days will be less and night will be wrong because it is a winter season.
But my humble submission is that crossing ಸ್ವಲ್ಪ ಆದರೂ ಕಾಂಟ್ರಿಬ್ಯೂಟರಿ ನೆಗ್ಲಿಜೆನ್ಸ್ ಹಾಕಿ ಅಂತ our request.
ಸರಿ.
ಇನ್ನೇನಾರು ನೈಟ್ actually we are not, my lord, we would not contend.
Okay.
ಅಲ್ಲಿ ರೋಡ್ ಲೈಟ್ ಇದ್ದಿಲ್ಲ ಅಂತದೆಲ್ಲ ಇರುತ್ತೆ. ಇದಾದ್ರೆ ಆಗಲ್ಲ, ಅರ್ಲಿ ಮಾರ್ನಿಂಗ್.
Yes, sir.
So far as negligence is concerned, the learned judge has elaborately discussed, and even the sketch exhibit P5 also shows that he crossed 3/4 of the road. There was a sufficient space to his left side for the offending vehicle. Therefore, the reason given by the learned judge is correctly appreciated, has to be appreciated by that. And
Yes.
so far as quantum is concerned, she was a tailor and a housemaker, and 12,000 rupees skilled worker. Actually, 12,000 rupees is quite reasonable. On the other hand, 10% has
What
not
is the evidence that she is a skilled worker, that is a tailor?
The tailor profession of tailor has not been denied by the
Sir, in the absence of any proof of the evidence, normally the notional income is required to be taken.
Yes, but the housemaker, and in addition to that,
Housemaker, though she is now the claimant, need not be considered as dependent, but he has lost his wife,
yes,
who was taking care of his entire managing the family, and he cannot get it managed through a paid person.
correct,
That is,
correct.
so that cannot be compensated in terms of money,
Yes,
because he has lost the companion at the fag end of his life.
correct, correct.
So that cannot be, that is okay. But taking income of 12,000 appears to be on higher side, but it can be by if future prospects are added, it will come to same thing.
Same, and instead of 8,64,000, it comes to 8,71,200. The difference is only 5,000 or 6,000, 6,000 rupees.
7,000.
Yeah.
7,000 order.
But so far as other heads are concerned,
Other rates are exorbitant, sir.
yes, yes.
Huh?
Yes.
So we will not disturb the income taken,
Yes.
but only will disturb the
Compassionate.
consortium and funeral expenses and other things. That can be reduced to 40,000,
70,000.
70,000.
Yes. And so far as interest is concerned, court has given reasons, and referring the Supreme Court judgment, 9% is quite reasonable.
But no, none of the bank gives 9% interest, sir.
But
ಯಾವ ಬ್ಯಾಂಕ್ ಒಳಗೂ ನಿಮಗ
ಅಲ್ಲ, ಅವಾಗ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ಇತ್ತು, ಅದನ್ನ ರೆಫರ್ ಮಾಡಿದ್ದಾರೆ.
ಬಟ್ ನೌ ಎವ್ರಿಥಿಂಗ್ ಇಸ್ 6%. ಮ್ಯಾಕ್ಸಿಮಮ್ ಈಗ 6 ಕೊಡ್ಬೇಕಾದ್ರೆ ಒದ್ದಾಡ್ತಾರೆ ಬ್ಯಾಂಕ್ನವರು.
ನಮ್ ಡಿಪಾಸಿಟ್ ಗೆ ಬರಲ್ಲ.
ಅಷ್ಟೇ ಸರ್.
Yes. This appeal is filed by the insurance company challenging the quantum of compensation awarded in emission number 399 of 2017 on the file of Small Causes Court, Nehal Unit, Bracket MSCP Tribunal dated 1st August 2017, whereby the tribunal has awarded total compensation of ₹10,09,000 with interest at the rate of 9%. For the sake of parties herein are referred with the original ranks acquired by them before the tribunal. The brief factual matrix leading to the case are that on 9/1/2017 at 5 a.m. deceased was crossing the outer ring road near Kartik Nagar bus stop in Bangalore city, and at that time driver of car bearing KA 53A8433 drove it in a rash and negligent manner and dashed against the deceased, who suffered fatal injuries on the vital part of the body and later on succumbed in the hospital. The deceased by name K. Subrathamma. The claimant, being the husband of the deceased, filed a claim petition under section 166 of any act claiming compensation. The tribunal, the insurance company has contested the matter, disputing the liability, and further asserted that there is contributory negligence on the part of the deceased while crossing the road. He has also denied the age, occupation, and income of the deceased. Considering these aspects, the tribunal has offered the total compensation of 10,99,000 under following head. 864(1). Being agreed by this award, the claim and the insurance company has filed this appeal. Third, the Learned Counsel for Appellant Insurance Company and Learned Counsel for Claimant Respondent perused the records. The Learned Counsel for Appellant Claimant would contend that the tribunal has committed an error in taking the income of the deceased at 12,000 in the absence of any material evidence, and as per Lok Adalat Act, it ought to have been 11,000. He would also contend that the compensation awarded under the head of loss of consortium, estate, and transportation of dead body, funeral expenses, etc., is on higher side. Hence, he would seek for reducing the compensation. He further submits that there is also contributory negligence on the part of the deceased, and the same may be taken note of. Per contra, the Learned Counsel for Respondent Claimant would support the judgment and award passed by the tribunal. He would contend that though the deceased was a skilled worker and income was taken at 12,000 cannot be treated as on higher side. He would also contend that no future prospects have been added, and hence he would contend that the compensation awarded is just and proper, and prayed for dismissal of the claim petition appeal.
Interest on higher, interest is higher.
Okay, the deduction was made towards 1/3. How it is
correct? Spouse, husband and wife. Even in Sarala Verma case, also spouse. Spouse means whether husband or
no,
wife.
no, I'm not coming to that aspect. Personal expenses 1/3 ಮಾಡಿದ್ದಾರೆ, only one dependent. Only one dependent, the husband.
Yeah, if there is one dependent, your lordship is correct. But the spouse, whether husband or wife, then 1/3 has to be deducted.
ಎಲ್ಲಿದೆ ಸರಳ ವರ್ಮದ Sarala Verma considers 2 and above.
ಅಲ್ಲ 2 and above ಅಂದ್ರೆ ಬೇರೆಯವರಾದ್ರೆ ಈ ಸ್ಪೌಸ್ ಆದ್ರೆ ಸ್ಪೌಸ್ ಅಂದ್ರೆ ಹಸ್ಬೆಂಡ್ ಆರ್ ವೈಫ್ ಸ್ಪೌಸ್ ವಿತ್ ವರ್ಡ್ ಯೂಸ್ಡ್ ಸ್ಪೌಸ್.
ನೀವು ಹೇಳಿದ್ದ ಇಟ್ ಕೆನಾಟ್ ಬಿ ಫೌಂಡ್ ಇನ್ ಸರಳ ವರ್ಮಾಸ್ ಕೇಸ್ ಸರ್. ಅದಿಲ್ಲಲ್ಲ. ಇನ್ ಕೇಸ್ ಆಫ್ ಸ್ಪೌಸ್ ಓನ್ಲಿ 1/3 ಅಂತ ಹೇಳಿ ಇಲ್ವೇ ಇಲ್ಲ, ರೆಫರೆನ್ಸ್ ಇಲ್ಲ ಅಲ್ಲಿ.
ವೈಫ್ ಆದ್ರೆ 1/3.
Married. If he is married, it should start with 1/3. That was the only observation in para number 30.
Correct. Married means husband and wife. Husband ಸತ್ತೋದ್ರೆ
dependency. Married ಅಂದ್ರೆ married dependency in case of siblings, parents, with reference. If he is married having a dependence, then it starts 2/3. If there are 2 or more dependents, it should be 2/3.
ಸರಿ ಬಟ್ ಸ್ಪೌಸ್ ದಿ ವರ್ಡ್ ಯೂಸ್ಡ್ ಸ್ಪೌಸ್
ಎಲ್ಲದ ತೋರಿಸಿ ಸ್ಪೌಸ್ is having, if he is having a spouse and she is the sole claimant, 1/3 is to be deducted ಅಂತ ಹೇಳಿ ಎಲ್ಲಿ ಹೇಳುತ್ತೆ ಅದು?
ಹಸ್ಬೆಂಡ್ ಸತ್ತೋದ್ರೆ ವೈಫಿಗೆ ಎಷ್ಟು 1/3.
ಎಲ್ಲಿದೆ ಅದು ತೋರಿಸಿ ಸರಳ ವರ್ಮದಲ್ಲಿ.
ನೋಡ್ತೀನಿ ಹೇಳ್ತೀನಿ ಸರ್.
ಹೇಳಿ.
ಎಲ್ಲ ತೆಗಿತಾ ಇದ್ದೀನಿ ನಾನು ಜಡ್ಮೆಂಟ್.
ನೋಡಿ ನೋ ಪ್ರಾಬ್ಲಮ್. Because 1/3 is statutory recognized under 163A.
ಅಲ್ಲ ಇದುವರೆಗೂ ನಾವು ಹಸ್ಬೆಂಡ್ ಅಥವಾ ವೈಫ್ ಇದ್ರೆ 1/3 ಅಂತಾನೆ ಡಿಡಕ್ಟ್ ಮಾಡ್ತಾ ಇದ್ದೆ ಎಲ್ಲ ಕೋರ್ಟಲ್ಲೂ. 9.
Paragraph 13 of the judgment, if I am right, my lord.
Para number 13 is only extraction of UPSRTC versus Trilochan.
ಇಲ್ಲಿ ನಾನು ಗೂಗಲ್ ತೆಗೆದು ನೋಡಿದ್ರೆ ಅದು ಬಟ್ such percentage of deduction is not an inflexible rule and offers merely a guideline. In Susama Thomas case, it was observed that in the absence of evidence, it is not unusual to deduct 1/3 of the gross income towards the personal living expense of the deceased and treat the balance as the amount likely to have been spent on the members of the family of respondents. In Trilochan case, this court has held that if the number of dependents in the family of the deceased was large, in the absence of specific evidence in regard to the contribution to the family, the court may adopt a unit method for arriving at a contribution of the deceased to his family. By this method, 2 units is allotted to each adult and 1 unit is allotted to minor, and total number of units determined. Then the income is divided by the total number of units. The quotient is multiplied by so and so, my lord. Then, my lord, example has been given. Though in paragraph 14 ದಲ್ಲಿ paragraph 14 ದಲ್ಲಿ ನೋಡಿ ಸ್ವಾಮಿ. Though in some paragraph 14, though in some cases, my lord, that I think your lordship got that.
ನೀವು ಹೇಳಿದ ಪ್ಯಾರಾಗ್ರಾಫ್ ಇದಕ್ಕೂ ಹೊಂದಾಣಿಕೆನೇ ಇಲ್ಲ, ಬಿಕಾಸ್ ಐ ಆಮ್ ರೆಫರಿಂಗ್ ಟು 2009 part 2 SCC.
ಅದೇ ಅದರೊಳಗೆ your lordship may kindly, I think, 14 ದಲ್ಲಿ I'll read out that, my lord, that particular paragraph itself for kind consideration.
ಅಲ್ಲ, ಯಾವ ಇದರಿಂದ ಸ್ಟಾರ್ಟ್ ಆಗುತ್ತೆ ಹೇಳಿ.
ಅದು ನಾನು ಇದರಿಂದ ಇಂಡಿಯಾ ಕಾನೂನು ಇದರಿಂದ ಡೌನ್ಲೋಡ್ ಮಾಡ್ಕೊಂಡಿದ್ದೆ. ಇದ್ರೊಳಗೆ ದೋ ಇನ್ ಸಮ್ ಕೇಸಸ್ ಆ ಡಿಡಕ್ಷನ್ ಪ್ಯಾರಾದಲ್ಲಿ, ಮೈ ಲಾರ್ಡ್, ಫಕೀರಪ್ಪ ಅಂಡ್ ವರ್ಸಸ್ ಕರ್ನಾಟಕ ಸಿಮೆಂಟ್ ಪೈಪ್ ಎಲ್ಲ ರೆಫರ್ ಮಾಡಿದ್ದಾರೆ ಸ್ವಾಮಿ. ಫ್ರಮ್ ಸುಷಮಾ ಥಾಮಸ್ ದಿಂದ ಮುಂದೆ 2 ಪ್ಯಾರ ಸುಷಮಾ ಥಾಮಸ್ ಡಿಸ್ಕಸ್ ಮಾಡ್ತಾರೆ ಇನ್ ಫಸ್ಟ್.
Yes, Sushma Thomas is discussed in para number 12.
ಅದಾದ್ಮೇಲೆ 100% ಅಂತ ಹೇಳಿ ನೆಕ್ಸ್ಟ್
Then para number 13 ಒಳಗ UPSRTC ತ್ರಿಲೋಕ್ ರೆಫರ್ ಮಾಡಿದ್ದಾರೆ.
ಹೌದು. ಆಮೇಲೆ
lack of uniformity, then the para starts with lack of uniformity.
ಕೈಂಡ್ ಕನ್ಸಿಡರ್ ಇನ್ ಫಕೀರಪ್ಪ ಅಂತ ಒಂದು ಬರುತ್ತೆ ನೋಡಿ ಸ್ವಾಮಿ. ಫಕೀರಪ್ಪ ವರ್ಸಸ್ ಕರ್ನಾಟಕ ಸಿಮೆಂಟ್ ಪೈಪ್ ಫ್ಯಾಕ್ಟರಿ ಅಂತ ಅದನ್ನು ಕನ್ಸಿಡರ್ ಮಾಡಿದ್ದಾರೆ. ಅಲ್ಲೇ ಮುಂದೆ ಫಕೀರಪ್ಪ ಕೇಸ್ ಆದ ನಂತರ ಫಕೀರಪ್ಪ ಕೇಸ್ ಆದ ನಂತರ ಸ್ವಾಮಿ, ಐ ಹೋಪ್ ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ ಗಾಟ್ ಇಟ್.
ಒಂದು yes, para number 29 ಫಕೀರಪ್ಪ ವರ್ಸಸ್ ಕರ್ನಾಟಕ ಪೈಪ್ ಫ್ಯಾಕ್ಟರಿ.
Yes, sir.
That is para number 13. Though in some cases you want to read.
Yes,
para number 30.
Correct. ಅದು one para ಹೆಚ್ಚಾಗ್ಬಿಟ್ಟಿದೆ ಮುಂದೆ. Though in some cases the deduction to be made towards personal and living expenses is calculated on the basis of units indicated in Tilak Chandra, the general practice is to apply standardized deductions. Having considered several subsequent decisions of this court, we are of the view that where the deceased was married, the deduction towards personal and living expense of the deceased should be 1/3. Where the number of dependent family members is 2 to 3, 1/4. Where the number of dependent family members is 4 to 6.
Para 30, where the having considered several subsequent decisions of this court, we are of the view that where the deceased was married. What is the meaning of married?
You cannot cut this sentence. See, you read the sentence as a whole, not cutting it.
Married, the deduction should towards personal and living expense of the deceased should be 1/3.
Comma ide, the deduction should be towards personal living expense, deceased should be 1/3. Continuous comma illa, where
the number of dependent family members
it makes lot of difference.
That is
Where
where the dependents are more, that is applicable. Where the person who is married, that is husband or wife, it is for 1/3. And for more deductions, or less deductions, the members have to be considered. How many members are there in the family?
Sir,
That is
just
the
go through the wordings used.
2 and 3 ಅಂತ
We,
specific ಆಗಿ
Allah, we are of the view that where the deceased was married,
yeah, correct.
comma, the deduction towards personal and living expenses of the deceased, comma, should be 1/3. Continue ಇದೆಯಲ್ಲಿ cut ಮಾಡಿಲ್ಲ ಅವರು. Where the number of dependents of family members-
where the dependent family members 2 to 3.
2 to 3 ಇದ್ದಾಗ
ಹಾ,
1/3 ಬರುತ್ತೆ. In case he is married, having number of dependents.
That is not correct. Where the members are more
No,
than
sir.
2 to 3,
You
1/4.
cannot split a sentence.
That is
Allah,
our.
I
that
don't
is
have
our,
any objections because the court is not paying, he is paying. There is no difference.
ಅಲ್ಲ ಇದುವರೆಗೂ
But,
ಅಲ್ಲ ಸ್ವಾಮಿ
The
ಇದುವರೆಗೂ
intention of the law laid down in Sarala Varma is not in respect of married person 50%. It makes it very clear when married, having a 2 to 3 dependents, it should be 1/3.
This is the first time we are hearing. Till today, court used to award where the wife was there 1/3 and husband was there 1/3.
Sir, ನಾನು ಅದಕ್ಕೆ ಮತ್ತೆ ಹೇಳಿದೀನಿ, ಅವ್ರ ತಕರಾರು ಇಲ್ಲ, ನಂದೇನು ತಕರಾರು ಇಲ್ಲ. ಮುಲ್ಕುಂದ್ ಅವ್ರು ತಕರಾರು ಮಾಡದಿದ್ರು ನಂದೇನು ತಕರಾರು ಇಲ್ಲ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದೀನಿ ನಾನು.
ಅಲ್ಲ ಅವ್ರು ಇದುವರೆಗೂ
But it is a question debatable issue. ಅದನ್ನ
ಹೆಗಡೆ ಅವರು ಇದುವರೆಗೂ ತಕರಾರು ಮಾಡಿಲ್ಲ. ತಾವು ರೈಸ್ ಮಾಡಿದ್ಮೇಲೆ ಅವರು ಡಿಪೆಂಡೆನ್ಸಿ ಕ್ಯಾಲ್ಕುಲೇಟ್ ಮಾಡಿ ಹೇಳಿದ್ರು ಕರೆಕ್ಟ್ ಆಗಿದೆ ಅಂತ ಹೇಳಿ.
ಅಲ್ಲ ಜುಡಿಷಿಯಲ್
ಇದುವರೆಗೂ our practice is that where the husband and wife is there 1/3. Other dependents.
But one thing, we consider it that is a different. But Sarala Varma doesn't say so as you put it. Sarala Varma says that a married person having a dependence 2 to 3 deduction should be 1/3.
We have to understand.
I have checked the evidence also.
Whether they are
having other children adu illa.
ಅಲ್ಲ ಈ ಮೊದ್ಲು ಮ್ಯಾರಿಡ್ ಸನ್ಸ್ ಮ್ಯಾರಿಡ್ ಡಾಟರ್ಸ್ಗೂ ಇರಲಿಲ್ಲ. ಈಗ 50% ಕೊಡ್ಬೇಕು. That is law is there is lot of evolution.
Notice sir, one or the other day this issue I will have to consider. ನಾನು ಮುಂದೆ ಬಂದಾಗ ನಾನು ಮಾಡ್ತೀನಿ. ಈಗ ಅವ್ರು ಸೀರಿಯಸ್ ಆಗಿ ಡಿಸ್ಕಸ್ ಮಾಡ್ತಾ ಇಲ್ಲ. He is selling.
My submission, one submission, my lord, to this effect. My lord, in this case, we have taken a specific contention that a deceased was a pensioner, drawing around.
Sir, I do consider that he is a pensioner.
Getting 28,000 rupees.
Sir, pensioner is different. She is serving him as a housewife.
Correct.
You cannot compensate a housewife. She is managing the house. So she is taking needs, food, everything. That cannot be compensated or equated with salary.
In terms of money, it cannot be, my lord.
Cannot be compensated. It is only because of love and affection.
That is what the Supreme Court also expressed.
So we cannot, that part, it is not fair.
Context is only this, my lord. Context is that already he was not dependent. In view of the Supreme Court judgment, he was not dependent.
Sir, he is dependent on his wife for everything. Because she is a wife. Money are nodbeku.
Correct.
Who has to take care of him? He is already crossed a senior citizen.
63 years.
And at the fag end of he has lost his partner. Who is there to share his feelings? Nobody is there.
Correct.
And I have searched for evidence whether they have got children or not. Adar ಬಗ್ಗೆ ಒಂದು word ಇಲ್ಲ. ಅದನ್ನು ಚೆಕ್ ಮಾಡಿದೆ ನಾನು.
ಇಲ್ಲ ಅಲ್ಲಿ ಒಂದು ಇದ್ರೊಳಗೆ ಕಂಪ್ಲೇಂಟ್ was lodged by his son, but he was not made party actually.
But quite natural, he doesn't become a party. That is a different aspect.
Yes. He has got son, my lord. Son is there. Your lordship.
ಅಲ್ಲ ನಿಮ್ ಪೆಟಿಷನ್ ಒಳಗೆ ಏನೇ ರೆಫರೆನ್ಸ್ ಇಲ್ಲ. ನೀವು ಅದನ್ನ ಡಿಫೆನ್ಸ್ ತಗೊಳ್ಳಿಲ್ಲ. ಟ್ರಿಬ್ಯುನಲ್ ದವರು ಕನ್ಸಿಡರ್ ಮಾಡಿಲ್ಲ.
ಅಲ್ಲ ನಮ್ಮ ಕಂಟೆನ್ಷನ್ ಅಷ್ಟೇ ಸ್ವಾಮಿ, ಮತ್ತೇನಿಲ್ಲ. We have taken that ground in the appeal memo and we will leave it to your lordship, my lord.
This will contain the compensation awarded just in proper and paid for this.
One line ಹೇಳ್ಬಿಡಿ ಸ್ವಾಮಿ, regarding he was earning he was a pensioner and getting 28,000 rupees. And because company should not think that we are not earned that ground. And also regarding interest, my lord.
Perusing the reports, he would also contain the interest awarded at 9% is on higher side and same request to be reduced. Having heard the arguments and perusing the reports, it is undisputed fact that the deceased so and so met with an accident on 9/1/2017 at 5 a.m. and succumbed because of the fatal injuries. The tribunal has taken income at 12,000, which is now disputed by the. So there is an assertion that deceased was a tailor. No material evidence is placed to substantiate said content. As per the Lok Adalat chart, this court is consistently taking the notional income of rupees 11,000 in respect of the which accident occurred in 2007. However, at the same time, it is also important to note here that the tribunal has not added future prospects of 10% considering the age of the deceased. Hence, if the as such, if the though the tribunal has taken the income on higher side, considering non-inclusion of the future prospects, it will rectified and it will could be lost. Hence, further, considering the age and occupation, the tribunal has applied proper multiplier and under the head of loss of dependency, tribunal has awarded 8,64,000, which does not call for any interference. The learned counsel would contend, the learned counsel for Appellate Insurance Company would contend that the claimant is the claimant is a pensioner and as such he cannot be treated as a dependent. But it is to be noted here that deceased was already a senior, the respondent claimant is a senior citizen, and at the fag end of his life, he lost his life partner, that is his wife. She was managing the family, and as such, that cannot be compensated in terms of money, and he is required to be treated as a dependent. Hence, the said arguments holds no water. The next one. The other contention raised by the learned counsel for appellant is regarding contributory negligence. But the said arguments holds no water since the deceased was crossing the road, and when she was almost crossed the road to the extent of 2/3, the offending vehicle moved on the wrong side and knocked her, resulting in the accident. Under such a the tribunal has, by giving proper reasonings, held that there is a actionable negligence on the part of the driver of the offending vehicle, and this reasoning does not call for interference. The tribunal has awarded consortium to the extent of 1 lakh, which is not permissible. The claimant respondent, being the husband, is entitled for consortium to the extent of 40,000 alone. Further, the tribunal has also awarded the compensation of 1 lakh under the head of loss of estate, which is also not permissible. He is entitled for only 15,000 under the head of loss of funeral expenses, loss of estate, and under the head of funeral expenses, tribunal is awarded 35,000, which is on higher side, and paid for only 15,000. Under such circumstances, the claimant respondent would be entitled for total compensation under various heads as under 864, 40,000, 15,000, 15,000. Plus 104 ಏನಾಗುತ್ತೆ ಎಷ್ಟು 9,34 ಆಗುತ್ತೆ ಕರೆಕ್ಟಾ? Hence, the claimant should be entitled for total compensation of the to the tune of 9,34,000 as against 10,99,000 awarded by the tribunal. Apart from that, tribunal has awarded the interest at the rate of 9%. But now considering the rate of interest being awarded by the banks and consistently the court is awarding interest at the rate of 6%, the interest awarded by the tribunal is on higher side. Hence, the interest is request to be reduced to 6%, and as such, the appeal needs to be allowed in part. Accordingly, appeal is allowed in part. The claimant is held entitled for total compensation 9,94,000 as against 9,34,000 as against 10,99,000 with interest at the rate of 6% per annum from the date of petition.
Amount in deposit.
Order regarding deposit and disbursement shall be as per the terms of the order of the tribunal. The amount in deposit shall be transmitted to the tribunal.
But any excess amount is there, it may be refunded. Any excess amount.
ಅಲ್ಲ ನೀವು ಎಷ್ಟು ಡಿಪಾಸಿಟ್ ಮಾಡಿದ್ರಿ ಈಗ?
50%. 50%.
50% ಅಂದ್ರೆ ಏನು ಬರಲ್ಲ, ನೀವೇ ತುಂಬಬೇಕಾಗತ್ತೆ.
65,000.
ನೀವು ಮ್ಯಾಕ್ಸಿಮಮ್ ನೀವು ರೆಡ್ಯೂಸ್ ಆಗಿದ್ದು 1,65,000.
1,65,000.
ಅದೊಂದು ದಿ ಬ್ಯಾಲೆನ್ಸ್ amount shall be deposited by the claimant.
Excess amount if any.
The excess amount if any deposited by the insurance company shall be refunded to the insurance company, and if there is any balance, the insurance company shall deposit the entire awarded amount with accrued interest thereon within 6 weeks.
Problem.
Shri Rajanna.
Claimant in case of death penalty.
One is by insurance company, na? Corporation. Involvement of two vehicles, huh? Head-on collision, huh? With Fisher's Puri. Liability is first and on. KSRC. You are for claimant. You are seeking announcement.
Future prospect award ಮಾಡಿಲ್ಲ.
First, let us hear his appeal first. ಯಾಕಂದ್ರೆ ನೀವು appeal announcement ಏನು ಎಲ್ಲ mathematical ಇದೆ. First, let us hear him. a bus was moving from ಅಲ್ಲ ರೀ ನಾನು ಕೇಳ್ತಾ ಇರೋದು ತುರುವೆ ಕಡೆಯಿಂದ ತಿಪ್ಟೂರ್ ಕಡೆ ಹೊರಟಿತ್ತ ತಿಪ್ಟೂರ್ ಕಡೆಯಿಂದ ತುರುವೆ ಕಡೆ ಹೊರಟಿ ತಿಪ್ಟೂರ್ದಿಂದ ತುರುವೆ ಕಡೆ ಬಸ್ ಹೊರಟಿತ್ತು ಕರೆಕ್ಟಾ Who is prosecuted against the driver of the KSRTC bus? The deceased was the rider of the motorcycle. Eleven feet ಇದೆ Yes, Sukil. The accident is almost in the middle of the road. Almost in the middle of the road. Have you examined the driver? What he has stated? MUR report. That is the best piece of evidence, already. MUR report ಎಷ್ಟಿದ್ರೆ exhibit? P14. The damage to the vehicle of KSRTC bus is on the left side. Yes. ಅಲ್ರಿ ಅದ್ರಾಗೂ ಕರೆಕ್ಟ್ ಅದಲ್ಲ ಅಲ್ಲ ನೋಡಿ ನೋಡಿ ಅಶೋಕ್ ಲೇಲ್ಯಾಂಡ್ ಕಂಪನಿಯದ್ದಾಗಿರುತ್ತದೆ. ಹಿಂಭಾಗದಲ್ಲಿ ಮೈಸೂರು ತಿಪ್ಟೂರ್ ಎಂದು ಇದ್ದು ಮುಂಭಾಗ ಬೋರ್ಡ್ ನಲ್ಲಿ ತಿಪ್ಟೂರ್ ತುರುವೇಕೆರೆ ಕೆಬಿ ಕ್ರಾಸ್ ಎಂಬುದಾಗಿರುತ್ತೆ. ಬಸ್ಸಿನ ಮುಂಭಾಗದ ಒಂದು ಎಡಭಾಗದ ಬಂಪರ್ ಅರ್ಧವರೆಗೆ ತಗ್ಗಿರುತ್ತದೆ, ಅರ್ಧ ಇಂಚಿನವರೆಗೆ. ಎಡಭಾಗದ ಹೆಡ್ಲೈಟ್ ಒಡೆದಿರುತ್ತದೆ. ಎಡಭಾಗದ ಇಂಡಿಕೇಟರ್ ಒಡೆದಿದೆ. ಬಲಭಾಗದ ಬಂಪರ್ ಸ್ವಲ್ಪ ಬೆಂಡ್ ಆಗಿರುತ್ತದೆ. ಮೇಜರ್ ಡ್ಯಾಮೇಜ್ ಇಸ್ ಟು ದಿ ಲೆಫ್ಟ್ ಸೈಡ್ ಅಗೇನ್. ಆಯ್ತು, ಬಲಭಾಗದ ಬಟ್ ಈ ಲೆಫ್ಟ್ ಸೈಡ್ ಡ್ಯಾಮೇಜ್ ಏನ್ ಹೇಳ್ತೀರಾ ಸರ್? ಆಫ್ಟರ್ ಇಂಪ್ಯಾಕ್ಟ್ motorcycle will be thrown outside. It will be thrown outside. It will not come back and again hit the way. ಅಲ್ಲ, ಎರಡೂ ಕಡೆ ಹೊಡಿಬೇಕಂತಂದ್ರೆ ಲೆಕ್ಕ ಹಾಕಿ ನೀವು. After impact he came left side. Allah, chances Allah. We are not here to act on the basis of chances. It is Allah. It is only a two-wheeler head-on collision in the middle of the road. Two-wheeler ಹೊಡೆದ್ರೆ one side ಹೊಡಿತಾರೆ, center ದಾಗ ಹೊಡಿಬೇಕು, left side ಹೊಡಿಬೇಕು, right side damage ಆಗಬೇಕು. Possibility is only in exceptional circumstances. So ಇಂಪ್ಯಾಕ್ಟ್ ಆದ್ಮೇಲೆ ಮೋಟರ್ ಸೈಕಲ್ ಹೋಗಿ ಬೀಳುತ್ತೆ, ಎದ್ದು ಬರಲ್ಲ. If that is if your argument is considered, what should be the speed of your vehicle? Right side dash ಆಗಿ ಲೆಫ್ಟ್ ಸೈಡ್ ಹೋಗ್ಬೇಕಂದ್ರೆ what should be your speed of the vehicle? ಸ್ಲೋ ಇದ್ರೆ ನೀವು ಆ ವೆಹಿಕಲ್ ಹೊಡೆದ ಬೇರೆ, the two-wheeler will come beneath the wheels of the bus, but not headlight damage ಆಗೋ ಚಾನ್ಸಸ್ ಇಲ್ಲ, because it will lie down. Who has to explain it? Whether your witness has explained? The driver, so-called driver, who is an expert in this regard, he is the best witness. One person is dead, who is supposed to answer, and the other person is your driver. Their evidence is against you. Allah, whatever it may be, they have deposed against you anyhow. Now the best witness is your driver is the best witness, alva. He did not explain how the damage to both the sides of the bus has occurred. His simple evidence is that head-on collision, driver helmet ಹಾಕಿರ್ಲಿಲ್ಲ, rider helmet ಹಾಕಿರ್ಲಿಲ್ಲ, ಬಸ್ ಎದುರಿನಿಂದ ಬರೋದು, ಬಸ್ ನೋಡದೆ ಕಣ್ಣು ಮುಚ್ಚಿ ಗಾಡಿ ಹೊಡೆದ ಆಕ್ಸಿಡೆಂಟ್ ಮಾಡಿದ ಅಂತ ಹೇಳಿ ಅವನ ಎವಿಡೆನ್ಸ್. This is the simple evidence he has given. He did not explain how damage was caused to the left side of the bus. ಮತ್ತೆ correct sir, what is the illegality? Because this is a beneficial legislation onnedu, and you will have to prove the other things if you want to take any advantage. ಏನು ಎವಿಡೆನ್ಸ್ ಇಲ್ಲ, ಒಂದು ಅಷ್ಟೇ. ಅವನು ಬಸ್ ನೋಡಲ್ದ ಬಂದ್ ಅವನೇ ನನ್ನ ಬಸ್ಸಿಗೆ ಹಾಯಿಸ್ದ, ನಂದೇನು ತಪ್ಪಿಲ್ಲ ಇಷ್ಟೇ. The accident has occurred around 4:15 p.m. Complaint was lodged in the evening at 9:30. ನೀವೇನ್ ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ರಾ? ನೀವೇ ಕಂಪ್ಲೇಂಟ್ ಕೊಡ್ಲಿಲ್ಲ? ಚಾರ್ಜ್ ಶೀಟ್ ಚಾಲೆಂಜ್ ಮಾಡಿದಾನ ನಿಮ್ ಡ್ರೈವರು? ಮಾಡಲ್ಲ ಅವನು. ಸರಿ ಸರ್. Date of accident 17/7/2016. Yes sir, 12,000 ತಗೊಂಡಿದ್ದಾರೆ. ಅಲ್ಲ ಅವ್ರು ಹೇಳ್ತಾರ, ಅವ್ರದ್ದು ಅದೇ ಗ್ರೌಂಡ್ ಇದೆ. ಕರೆಕ್ಟ್. ಫ್ಯೂಚರ್ ಪ್ರಾಸ್ಪೆಕ್ಟ್ಸ್ ಕೊಡ್ಬೇಕು. What is his age? So 40%. What is his age? 47. Okay, 25% future prospects. Conventional head, sir. Loss of consortium 1 lakh. This was the Nagaraja. Huh? Sangappa. Who is claimant number 3? Srimati Nandana. Daughter, married daughter. She cannot become. Hello, mother is there. Allala, Gaurama. Srimati Gaurama is the widow, elder sister. She is also, she cannot be treated as a dependent. Allah. But ಅದು ಕರೆಕ್ಟ್ ಆಯ್ತು. ಇಶ್ಯೂ ಈಸ್ 1 lakh ಕೊಟ್ಟಿದ್ದಾರೆ, 80,000 ಕೊಡ್ಬೇಕಾಗಿತ್ತು. ಕನ್ಸೋರ್ಟಿಯಂ ಲವ್ ಅಂಡ್ ಅಫೆಕ್ಷನ್ 1 lakh ಕೊಟ್ಟಿದ್ದಾರೆ. ಫ್ಯೂನರಲ್ ಎಕ್ಸ್ಪೆನ್ಸಸ್ 25 ಕೊಟ್ಟಿದ್ದಾರೆ. 1:20 ಇಲ್ಲೇ ರೆಡ್ಯೂಸ್ ಆಗುತ್ತೆ ಇಲ್ಲೇ, ಯಾಕಂದ್ರೆ 1 lakh ಪರ್ಮಿಷನ್ ಇಲ್ಲ. ಸಿ ಇದು 25,000 ಇಲ್ಲ, ಹಾರ್ಡ್ಲಿ 15,000 ಅಲ್ಲ. ಅದನ್ನೇ ಕನ್ಸಿಡರ್ ಮಾಡಿದ್ರೆ 80,000 ಪ್ಲಸ್ 30,000 110 ಬರುತ್ತೆ ಟೋಟಲ್. 110 with 225 110 ತೆಗಿಬೇಕು. 115 is extra. Simple calculation. ಈಗ ಈಗ ನಿಮ್ದು ಹೇಳಿ. ಎನೌನ್ಸ್ಮೆಂಟ್ ಬಂದಿದ್ದೀರಿ ನೀವು, ನಿಮ್ದು ಹೇಳ್ರಿ ನೋಡೋಣ. What is the evidence? Agree, RFR produce ಮಾಡಿದೀರಾ? The whether the land shall be in RTC extract ಇದೆ. Land still remain there itself.
Is supplying the milk to the.
What is the income? ಅದನ್ನ ಸಿ ಸೊಸೈಟಿಗೆ ಹಾಕಿದ್ರ ಅಂದ್ರೆ ನಿಮಗೆ ಸೊಸೈಟಿ ಅವ್ರು ಇದನ್ನ ಕೊಡ್ತಾರ. ಇರ್ಲಿ ಅದೇ income. If you want to go against the settled norms, you will have to prove that your case falls under special exceptions. Merely pleading that I'm a milk vendor, I'm having this of land is not a ground. And lands remains as it is. That is not a ground. That cannot be a ground, sir. Only earning capacity we are considering. ನಿಮ್ದು ಎನಾನ್ಸ್ಮೆಂಟ್ ಏನ್ ಹಾಕಿದ್ರಿ ನೀವು? ಎನಾನ್ಸ್ಮೆಂಟ್ ಏನ್ ಗ್ರೌಂಡ್? ಫ್ಯೂಚರ್ ಪ್ರಾಸ್ಪೆಕ್ಟ್ಸ್ ಹಾಕಿದ್ರು ಬರುತ್ತಾ ನಿಮಗೆ ಇಷ್ಟ ಈಗ? ಬಿಕಾಸ್ ಈಗ ನೀವು ನೋಡ್ರಿ ಕ್ಯಾಲ್ಕುಲೇಟ್ ಮಾಡ್ರಿ 9,500
2375 ಬರುತ್ತೆ. ಅದನ್ನ ಆಡ್ ಮಾಡಿದ್ರು ಕೂಡ 11,875 ಬರುತ್ತೆ.
11,875 into 12 into 13 ಎಷ್ಟಾಯ್ತು?
18,52,500 ರೂಪಾಯಿ. 18,52,500.
ಅಲ್ಲ ಇದು ಸೂರಿ ಡಿಡಕ್ಷನ್
ಇದ್ರಲ್ಲೇ ಒಂಥರ ಲಾಸ್ಟ್ ಡಿವೈಡೆಡ್ ಬೈ 3 ಮಾಡಿದ್ರೆ 6,17,500. $12,35,000 ಹೋಗಿಲ್ರ. 12,48 ಇದ್ದಿದ್ದ 12,35,000 ಆಗುತ್ತೆ. Loss of dependency ಕೆಳಗಡೆ plus 80,000 plus 15,15 80 15,15 13,45,000.
13,45,000 ಆಗುತ್ತೆ. 14,73,000 is awarded. ಏನ್ ಹೇಳ್ತೀರಾ? ನಿಮ್ದು ಅಪೀಲ್ ಏನಾಗುತ್ತೆ? Their appeal is to required to be allowed. ಏನ್ ಮಾಡಕ್ ಬರಲ್ಲ. Are filed under section 173 clause 1 of any act challenging the judgment and award passed by the MSCT Bangalore SCCH 17 in emission number 7012 of 2016 dated 5th August 2017, whereby the tribunal has awarded a total compensation of rupees 14,70,000 with interest at the rate of 7.5% per annum. MFA 8958 of 2017 is filed by the claimants seeking enhancement, while MFA 12 of 2018 is filed by the corporation on the ground of contributory negligence as well as seeking reduction in the compensation awarded amount. The brief factual matrix lead for the sake of convenience, but the brief factual matrix leading to the case are that deceased that on 7/3/2016, the deceased was riding motorcycle bearing KA 44/K0954 towards Guddanahalli from Turvekere, and at that time KSRTC bus bearing KA 06F7050 driven by its driver in a rash and negligent manner from opposite direction and dashed against the motorcycle, and due to the said impact, the deceased sustained fatal injuries and succumbed on the spot. It is asserted that the deceased was earning rupees 10,000 per month by milk vending business and 10 to 15,000 from agriculture. The claimants alleged to be the widow, son, daughter, and sister have filed the claim petition under section 166 of any act seeking compensation of rupees 30 lakhs on account of untimely death of Thangappa, deceased Thangappa. The corporation has registered the claim by filing objections and further asserted that the deceased, the extent is because of actionable negligence on the part of the deceased as he moved on the wrong side, which has resulted in the extent. He has also denied the age, occupation, and income of the deceased, and as such disputed the liability. The tribunal, after appreciating the oral and documentary evidence, has awarded a total compensation of rupees 14,73,000 to the claimants under following heads, individual heads. Being aggrieved, being dissatisfied with this award, the claimants have filed MFA 8958 of 2017 seeking enhancement, while the corporation has filed MFA 12 of 2018 challenging the quantum. Heard the arguments advanced by the learned counsel for claimant as well as the corporation. Quantum as well as negligence. Heard the learned counsel for claimant and respondent corporation. That is the reports. The learned counsel for claimant would, what is your ground enhancement again? The learned counsel for appellant claimant would contend that the tribunal, though awarded compensation under proper heads, it has failed to add future prospects to the extent of 25% in view of the considering the age of the deceased. Hence, he would seek for enhancement. Next. Per contra, the learned counsel for corporation would contend that The tribunal has taken the income of the deceased at 12,000, which is on higher side in the absence of any material evidence, and the tribunal ought to have taken income at 9,500. He would also contend that there is contributory negligence on the part of the deceased as he was moved on the wrong side, which has resulted in the accident, and as such, he disputed his claim. Next. Having heard the arguments and perusing the records, the tribunal has, after appreciating the evidence, has come to a conclusion that the accident in question is because of actionable negligence on the part of the driver of the KSRTC bus. The sketch of the scene of offense discloses that accident has occurred in the middle of the road. At the same time, it is evident from exhibit P3. But from exhibit P14, it is evident that damage to the bus was on the left side of the vehicle. Left side bumper and left side headlights were damaged. No doubt there were damages also on the right side of the bus, and same is again supported by the Caesar Mahazar exhibit P5. The driver of the offending bus was examined as RW1, but he did not explain as to how the damage to the bus on the left side were caused. The tribunal has considered all these aspects, and after appreciating exhibit P5 and P17, has rightly fastened the liability on the driver of the offending bus. Considering the evidence on record, I do not find any ground to interfere with the finding of the tribunal regarding negligence aspect. Next. The tribunal has taken the income of the deceased at 12,000. No doubt it is asserted that the deceased was earning rupees 10,000 from milk vending, and he had agricultural income of rupees 10 to 15,000 per month. But to substantiate the said contention, no other material evidence is placed except RTC extracts. Mere production of RTC extract does not establish the income. In the absence of any material evidence, the notional income is required to be taken as per the Lok Adalat chart. This court is consistently taking the income at 9,500 in respect of accidents which occurred in the year 2014-16. Next. The tribunal has not considered future prospects. Admittedly, the deceased was aged about 47 years, and hence 25% of future prospects are required to be added. If his income is taken as 9,500 per month, the 25% of the future prospect would work out at 2,375, and his income would be 11,875. He had 2 dependents, and 1/3 is required to be deducted. Hence, he would have contributed 11,875 divided.
3,959.
Hence, the loss of dependency would work out as 11,875 into 12 into 13 into 2/3. ಎಷ್ಟಾಗುತ್ತೆ ಈ ರೀತಿ 11,875 into 12 into 13 into 2 into 3 divided by 3. $11,875 into 12
into
13 into 2 divided by 3.
12,35,000.
12,35,000. Hence, the loss of dependency would work out as 12,35,000. The tribunal has awarded 12,48,000, which is on higher side. Even the future prospects are added. Next paragraph. The tribunal has awarded rupees 1 lakh under the head of loss of consortium without any basis. There are the appellant number 1, the petition claimant number 1, Sumitra, is the widow, while claimant number 2 is the son. The claimant number 3 is the married daughter, while claimant number 4 is the elder sister. Hence, claimants 1 to 3 are entitled for 40,000 each. That is 1,20,000. Further, the tribunal has awarded 1 lakh under the head of loss of love and deprived protection, social security, etc., which is not permissible. Towards funeral expenses and transportation, tribunal is awarded 25,000 also on higher side. The claimants are entitled for rupees 15,000 under the head of loss of estate and 15,000 under the head of funeral expenses. Hence, the claimant should be entitled for total compensation of rupees 12,35,120 plus 30,000. Yes. Yes, 13 lakhs 85,000. 80,000 because daughter is entered. The tribunal has awarded rupees 14 lakhs 73,000 as against 13 lakhs 85,000, which is on higher side. Hence, the appeal filed by the insurance company in MFA 12 of the corporation in MFA 12 of 2018 needs to be allowed in part, while the appeal filed by the claimants in MFA 8958 of 2017 needs to be dismissed. Further, the tribunal has also awarded interest at the rate of 7.5% without there being any basis. This court is consistently awarding interest at the rate of 6% and interest. Hence, the interest requires to be reduced. Accordingly, proceed to pass the following order. MFA 12 of 2018 is allowed in part. The claimant are held entitled for total compensation of 13,85,000. Wait, madam. 5,000 as against awarded by the tribunal with interest at the rate of 6% per annum from the date of petition till the realization. The amount in deposit statutory deposit ಮಾಡಿದೀರಾ ಡಿಪಾಸಿಟ್ ಮಾಡಿದೀರಾ ಇಲ್ಲ ಮಾಡಿದಿರಲ್ಲ ಅದನ್ನ ಮೊದಲು ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡ್ತೀನಿ ಸರ್ ಇಲ್ರ ಯಾಕೆ ಟೆನ್ಷನ್ ಮಾಡ್ಕೋತೀರಾ ದಿ ಅಮೌಂಟ್ ದಿ ಸ್ಟ್ಯಾಚ್ಯೂಟರಿ ಡಿಪಾಸಿಟ್ ಮೇಡ್ ಬೈ ದಿ ಕಾರ್ಪೊರೇಷನ್ ಶಾಲ್ ಬಿ transmitted to the tribunal. The amount, if any, paid by the corporation to the claimants shall be adjusted in the award amount. Aita? Huh? Oh. Mag operative portion. It is also admitted fact that 50,000 is already paid to the claimants by the corporation, and same is required to be deducted from 13,85,000, and as such claimants would be entitled for 13,35,000 in all. Hence, 13 lakh with interest 6%. ಅಲ್ರಿ ಇನ್ನೊಂದು ಅರ್ಥ ಆಗಲಿಲ್ಲ. ಪೆಟಿಷನರ್ ನಂಬರ್ 4 ಗೆ 30% ಕೊಟ್ಟಿದ್ದಾರೆ. ಏನ್ ಯಾವ ಬೇಸು? ಎಲ್ಡರ್ ಸಿಸ್ಟರ್ ಏನು ಡಿಪೆಂಡೆಂಟ್ ಇರ್ಲಿ, ಸಿ ಇಸ್ ನಾಟ್ ಎ ಕ್ಲಾಸ್, ಅವ್ಳಿಗೆ ಹೆಂಗ್ 30% ಕೊಡ್ತೀರಿ ಮಕ್ಕಳಿಗೆ? ಸಿ ಇರ್ವಲ್ದಕ್ಕೆ, ಬಟ್ 30% ಬಹಳ ಆಯ್ತಲ್ಲ. ಬಟ್ ಏನೋ ನಿಮ್ಗೆ ಬರೋದದು. ಐ ವಿಲ್ ನಾಟ್ ಡಿಸ್ಟರ್ಬ್ ಇಟ್. ದಿ ಡಿಪಾಸಿಟ್, disbursement and apportionment shall be as per the order of the tribunal. Yes, madam. $40,000 add, but 2,500. 2,000? Yes.
Each of the claimant was 19 years old at the time of accident.
What is the nature of injury? ಎಲ್ಲ 7 ಇರಲ್ರಿ. ನೇಚರ್ ಆಫ್ ಇಂಜುರೀಸ್ ಒಂದ್ ಹೇಳ್ರಿ. ಗ್ರೀವಿಯಸ್ ಇಂಜುರೀಸ್, ಅಬ್ರೇಷನ್ ಅವೆಲ್ಲ ಬೇಡ. ವಾಟ್ ಆರ್ ದಿ ಇಂಜುರೀಸ್?
Soft tissue injuries of the face, closed head injuries. These are the 4 major injuries. Closed head injury.
Closed head injury ಅಂದ್ರೆ ಏನು?
Close.
If it is to be it is stated. If you want that court to look and write, then there is no need to you to argue the matter. See, I am asking you. You are arguing the matter. What is mean by head injury? What is the nature of head injury? What part of the head is fractured? Whether it is a parietal bone, whether a temporal bone. Then how it can be considered as a grievous injury? Come prepared. Come prepared. As per request, leave the matter next week.
Is it serial number 40, my lord?
Sir, ಅವರು ಪ್ರಿಪೇರ್ ಆಗಿ ಬಂದಿಲ್ಲ, ಅದಕ್ಕೆ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಇಟ್ಟಿದ್ದೀನಿ. She is not able to say what are the nature of injuries. Let her prepare herself. You should be in a position to give a feedback to the court. That is stated. Then there is no need for you to argue the matter. I'll look into it. See, that is stated there. Everything is stated. Then why you are here?
That's why I'm assisting the court.
See, you are first. You will have to state what is stated. where the tribunal has committed an error. Come prepared. You are unable to say what is the nature of injury, where the exactly, whether it is a fracture of frontal bone, temporal bone, parietal bone. It is mentioned there in the document. If that is the case, I'll look into it. What was your need? What you are assisting, you are unable to say what type of injury is caused, what is the fracture. And you are saying that you are assisting the court. Is it an assistance expected? Note Banbekri, nature of injury and what is the consequences of that injury on his future prospects? What is the medical evidence, whether he is a treated doctor or is otherwise doctor? What he has given evidence? What is his percentage, whether where the tribunal has taken it properly or wrongly? What is the impact of the fracture of frontal bone? How it has come in the way of his earning capacity? I am assisting and nintra agalladu. ಏನು ಹೇಳಿದ್ರೆ ಇನ್ನ ಅರ್ಥನ ಆಗ್ತಾ ಇಲ್ಲ.
The ground. So is that?
Your appeal is 8348.
8348.
The named counter appeal, yours is for enhancement. You are for challenging the liability. Only quantum. Negligence and interest only. Yes. Case of injury, alva.
There was a rider and two Chilean riders were there on a motorcycle.
Yes.
Our contention is that the rider of the motorcycle was not wearing the headgear, helmet active, and the injuries are there's a
Head injury.
Therefore, our contention was that since it was not wearing headgear as contemplated particular motor vehicle act, some attribution towards contributory negligence ought to have been taken because it is in violation of the motor vehicle act. Clauses 1.8. The accident is past. I did not offending vehicle. 6 months he was not wearing the helmet.
Wearing, non-wearing of the vehicle has whether it has contributed to the extent.
That is not more evidence. But not be that as well, there is violation.
It has only aggravated the injury. Yes. Aggravated the injury. Yes.
16 of judgment. 16.
Yes.
These are the injuries which he suffered. 6 injuries.
All are head injuries.
All are head injuries.
Yes.
The case not suppose he was wearing the gear.
These injuries could have been avoided.
Injuries could have been avoided or could have been very minimum. That is my lord's contention. Therefore, the Honorable Lord's Madras High Court in the same scenario has taken contributory negligence to an extent of 50%.
Page, para number?
Paragraph number 5.
Yes.
There is master one goes for the second response, insurance company, covered the driver of the two-wheeler, not the helmet at the time of accident, therefore contributory decreases as started over. Nothing was for the appellate. So it will decreases to the right driver of the driver. Only when therefore there is no contributory decrease in part of the deceased. Further, the function for the appellate to submit that no future prospect was added to the income of the or the driver also determines the removal of the record will show that the deceased was riding his two-wheeler in the right direction as proved by the eyewitness. Further, there is no evidence on the side of the respondent. Therefore, the driver, however, para 7, however, rightly pointed out by Mr. Bhaskar, government wants to present the respondent deceased rider was not wearing helmet at the time of accident. Therefore, contributory negligence has to be fixed. 128 of the Motor Vehicles Act mandates wearing of wear/helmet. The rider shall wear helmet. It is not the case of the payment that the rider was wearing helmet as per section 128 of the Motor Vehicles Act. Therefore, 50% contributory negligence has to be for the deceased driver. Yes, this case also not there is from the investigation. Not forthcoming that the rider was wearing helmet. And not he was carrying two-wheeler adult and one child.
Yes.
Since you are not wearing the gear, there are no severe injuries and doctors also examine. The disability is 40% to the whole body. Or suppose he was wearing helmet, the
injury could have been gravity of injury could have been reduced considerably.
And the industry is awarded with 8%. These are very good.
Yes.
In fact, our High Court was ordinate bench. This is Lara from this one. Paragraph number 80. This is the finding after discussion of all the origins and before parting with this matter, it is proper to observe that the case tribunal, the dealing with the case for compensation shall have to record a finding as to rider or female rider wearing a helmet of a required standard in case of two-wheeler and occupants of the car wearing seatbelts not to be entitled for compensation. If it is found that there is violation, not wearing the proper headgear or seatbelts, claimant to be denied compensation. In this case, the observation is that not the entire compensation should be denied.
Yes. That is the basic. Now you are raised a legal issue. Only two withdraw legal issue allowed. Yes, sir.
If satisfies
They become a third party alva. Here the injured himself is a rider of the vehicle. You are a third party, but you are a rider of the other vehicle without wearing a helmet and or contention. Allah penalty early. See why the strict rule of wearing helmet should be made? What is the need of the legislation to incorporate such a strict? If these are to be floated in a day and night, and filing the claim petition, they are being floated openly. See, there are two options. For others, there are two options. One is they can proceed against him. They can also proceed against the present claimant also. They have chosen the other forum. That cannot be a ground here. Here he himself is a party. So satisfaction of the claim in other claim petitions will not come to the aid of this person, who is the rider. See, the wearing of the helmet is to avoid head injury, which is fatal. Accident is an accident. Nobody is intended. It happens. Nobody knows how it happens. In a spur of moment, accident takes place. Without anticipation, it takes place. But the fact that to minimize the damage or injury, helmet is made as a compulsory. And by floating the rule, a person rides a vehicle without wearing helmet and sees that he suffered a disability, and therefore he should be compensated. He should be compensated. There is no dispute. The negligence on the part of the offending vehicle, no dispute. But had you taken a proper precaution as per the MU Act, the rules of MU Act, provisions of MU Act, what would be the effect? You would have suffered minimum injuries. You would not have suffered all this trauma, isn't it? Then ఏంటి ಅಲ್ಲಲ್ಲ ದಿಸ್ ಇಸ್ ದಿ ಸಿಂಗಲ್ ಬೆಂಚ್ ಇರ್ಲಿ, ಇದು ಸೆಟ್ ಅಸೈಡ್ ಮಾಡಿದಾರೆ, ಅಬ್ಸರ್ವೇಷನ್ ಸೆಟ್ ಅಸೈಡ್ ಮಾಡಿದಾರೆ. ಏನಂತೆ ಎಲ್ಲಿದೆ? Mere violation of traffic rules is different. This is not wearing mandatory. ಕೊಡಿ ಅದನ್ನ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ ನೋಡೋಣ. If there is if it is covered by decision, we don't have any issue, because we will have to follow it. Monday, Tuesday. Okay, Tuesday.
ಯಾರು ಮಾಡಲ್ಲಪ್ಪ ಇವಾಗ.